Mr. Raidani, Vijay, are you there?
Yes, I'm here.
Thank you. Now I'm going to recognize Advocate Bauer, and I'm going to ask you to wrap up in the next 15 minutes. Thank you. Over to you.
Advocate Radani, I just have one aspect that I want to deal with you, and that is a comparison in some ways between the final report and the document which is attached to your affidavit called NR10. And I'm going to just ask him to put page 1268 of the final report, the signed report, which is part of bundle A. And if we go to page 1268, and because I'm on time restrictions, I'm just going to highlight a couple of stuff on the final report and then take you, actually, I should probably do it the other way around. Sorry, Shepherd. First put up NR10, because that's the earlier version, and take us to page 3128. Right, and one sees at page 3128, there is a finding in respect of under observations, sorry, at 6.1.2, 6.1.4, do you see that?
Yes, I see it.
Right. This is the report that was there. It says at 6.13 that the public protector, in concurrence with the Accountant General's investigation, observed certain issues relating to procurement processes in regard to the project. And then at 6.14, it says the prescripts in respect of the procurement of the agreement was not adhered to. If you just go down on the report, and then it says the accounting officer of the department proceeded with the recommendation of the Accountant General to pay a further 143,950 million to Estina in respect of the project. This amounted to gross irregularity and maladministration.
Yes.
Right. So that's the one observation, and I'm just going to take you to 2 or 3 more in the documentation. If you go to page 3047, no. Sorry, hold on. The chair's now disconcerted me with that announcement, so let me not lose my train of thought. If we go to page 3130, right, if you go down, just go a bit slower, else I'm going to lose go to the heading. You see whether it says, regarding whether the department failed to manage and monitor implementation of the terms of the agreement in relation to budget evaluation, expenditure control and performance. And then if you go further down, you will find a allegation that it's at 6.24, sorry. The evidence outlined earlier points to gross irregularities ensuring the effective and efficient performance of the agreement resulted in irregular and fruitless expenditure. And then if you go to the next page, which is 3131, you will see 6.31. It says the allegations that the prices for goods and services procured were inflated, specifically expenses in respect of construction, processing equipment, procurement of cows, and administration costs is substantiated. And I just want to put two more to you. You will see at 6.34 and 5, the lack of proper monitoring and control measures to ensure value for public money expended is the reason for the discrepancies, and this amounts to gross negligence, maladministration, and irregular and frivolous expenditure. And the next paragraph says the evidence submitted indicates that the prices of the milking equipment, the gate and guardhouse, and the cars were considerably higher than the prevailing current and market prices. And then if we just go to remedial action at 3133. It's a heading that says remedial actions. Just go higher up. Are you on 3133? There we go. Let's go down. You see there under 7.1.3, let's go a little bit up, sorry, 7, so that we can see what the heading is, 7.1.1. It's the remedial action in respect of the Premier of the Free State Province, right? And if we go down, it says it must, at 1.3, go. It ensures that the findings of the Accountant General and the recommendations of his report be implemented, right? And in respect of the HOD, it says they must improve the supply chain management systems of the department to ensure that all treasury regulations and prescripts are adhered to. And then under 8 on monitoring, you have 3, right, it says the Premier and the HOD are required to take remedial action, must acknowledge receipt and advise on the acceptance of the report. It must then implement an action plan and submit bi-monthly reports, and go down 1. And it must refer to the Auditor General, the NPA, and the Directorate of Public Priority Crime Investigations. Now, these are some of the conclusions that remain in the report that you that the task team people were working on the evening on the 8th. Correct, Mr. Radani?
That's correct.
Right, now I want to just compare those with the provisions in the final report that was then signed on that evening. And if we start at page 1268, you'll see at 6.1.4 observations. It differs in it says that the public protector, in concurrence with the Accounting General's investigation, observed the following procurement irregularities. And if you turn up, or you go to the 6.15, it says that the prescripts in respect of the procurement of the agreement was not adhered to. Do you see that?
Yes.
So it's taken out the categorization which the previous version had of maladministration.
Yes, that's correct.
Right, and then if you look at page 1 to 70, you will see that at 6.25, it says it is clear that this amounts to gross negligence and also constitutes improper conduct as envisaged in 182 of the Constitution, and maladministration as envisaged in Section 6 of the Public Protector Act. So that finding is there, correct?
Yeah, it's correct.
But what it doesn't do is it doesn't say non-compliance with Section 217 of the Constitution, the conclusion of the agreement improper, correct?
Yeah, that provision related, that information relating to section 217 was removed.
Right. And then if it comes to 6.3, where you deal with the prices of goods and services, whereas it had previously indicated that they were inflated under 6.3.1, you now say the allegations that the prices for goods and services procured were inflated, specifically expenses in respect of construction, processing equipment, procurement of cars and administrative costs. It's now difficult to determine. I'm now at 6.3.1, right? And at 6.3.1.2 is the sentence that says, due to the lack of resources and financial constraints, the public protector was unable to conduct a comprehensive investigation in order to determine the fair market value of goods and services. So there's no findings of irregular and fruitless expenditure any longer.
Yes, that's correct.
Right. And if we go to the remedial action, before I get kicked off, just to make the last point on that, with respect to the Premier at 1271, it deletes the two requirements that the Premier must implement the findings of the Accountant General and submit its report to the provincial legislature, but it now says that under 7.3.1, the Premier must ensure that he conducts a reconciliation of the number of cows initially procured and found during April 2017 as per his undertaking in his section 7.9 notice. You see that?
I see that.
And then, so that also differs from the previous version. And then at paragraph 8, when it comes to monitoring, if you just go down, oh, sorry, I've left out the HOD. The requirement of improving the supply chain management is no longer there. But if you go down to monitoring, the last one on the previous draft that indicated a referral to the Auditor General, the NPA and the Directorate, that too is no longer there.
Yes, that's correct.
Right. Mr. Radani, you accepted that at the end of the day, it's the Public Protector's report, and what she wants in that report is up to her. Do you agree?
Yeah, that's correct.
Okay. I have no further questions.
Thank you. You're just on time on the 15 minutes, yet you've just saved 3 minutes of that. Good. Thank you, Advocate Bauer. I'm now going to check and invite Advocate Mpofu to start the cross-examination. Welcome, Advocate Mpofu. I hand over to you.
Thank you. Good afternoon, Chairperson and everybody. Good afternoon, Advocate Radani.
Good afternoon, Advocate Mpofu.
How are you this afternoon?
Very well.
How are you this afternoon?
Let's see, just a pause, Advocate Mpofu.
Okay, not bad.
You can show the picture again and see whether it's not holding up now. Mr. Raidani.
Yes,
Advocate Radani.
I think you are cutting Advocate Mpofu SC.
Advocate Mpofu, are you there? Advocate Mpofu, are you there? Looks like Advocate Mpofu is not ready for you. So let's wait for him and be patient. We'll wait for him to come back. Are you back, Advocate Mpofu? We lost you. You are muted. You are muted. You are muted.
Am I audible now?
Yes, please start again because we lost you.
Yes. How are you, Advocate Ndichenye?
I'm fine, SC. How are you?
No, I'm doing very well. Thank you very much. Yeah. I hope you're not doing this from chambers in Senton.
No, I should have come straight over. I should have walked over to your chamber. We're on the same floor.
Thank you. All right. Well, I agree with Advocate Bauer only with one thing, that your choice of profession is not advisable. But yeah. So listen, we're going to just deal with a few issues, but before we do that, I just want to just to address the chairperson. What I propose to do just to try and save time is, and I've discussed this with Advocate Bauer, I'm not going to deal with some of the let's call it the general issues that we have already dealt with other witnesses, where it is known what our position is. You know, things like the dissolution of the think tank and all that. But so if I don't deal with those, it must not be taken that because I didn't put it to this witness that we accept his version, because the committee already knows what our view is. So I don't want to go into a blow-by-blow issue about whether it was a weekly meeting or a quarterly meeting. I think we've exhausted those issues. If that is okay with you, Chair, then I'll go straight into the main issues.
That's perfectly in order, Advocate Mpofu. Please proceed.
Thank you, Chair. Yes, I just don't want it to be held against me at some stage later. Thank you very much. Advocate Radani, would it be fair to say that you don't really have much to offer to assist us with, either because your memory is not up to scratch, or you're not sure of some of the things that happened, or as I'm going to suggest, I think you were only marginally involved in respect of the Friede report, because you only really participated in the last two, towards the tail end of that report. Would that be a fair assessment generally?
Not really. I would say
okay.
What I can contribute towards this committee, it's only in relation to the Friede investigation, and also my short stay as a senior investigator in the private office, and of which is a fairly short amount of time, which cannot, maybe unlike other witnesses who have a long testimony, but mine is limited to Friede investigation and also the short stint that I was in the private office.
Yeah. No, I think maybe you didn't understand. Yeah, I think we're in agreement. So I'm saying, therefore, for those reasons, you have very little to offer on the broader issues, but only to that limited extent, correct?
That's correct, Mr. Mpofu.
Yes, thank you very much. Yeah, all right. And also, just to be fair to you, I think that the way you've drafted your affidavit also indicates that kind of, minimal contribution, because it's littered with words like, to the best of my recollection, in my perception, if my memory serves me well, and so on. Those kinds of qualifications, which really indicate that you, and it's understandable, you didn't want to assert things as certainty when they are not clear in your own mind. Am I right?
That's correct. And also I didn't want to put allegations that I was not going to substantiate. And for the reasons that you stated, and I stated before, that my involvement, much as it has to do with the current inquiry, it has to do with the Friday investigation and that particular time that I was in the PP's office.
Yes, no, fair enough. In fact, to be fair to you, those kinds of broad qualifiers relate to the kind of more general issues, such as the issue about think tank and so on. But the point is that, and I'm saying this in your favor, that where you need to qualify the statements, you make it clear that this is just your perception, or that you might not have a full recollection, instead of putting it as certainty. Okay?
That's correct. As far as I can remember, especially where the allegations were vague. And if you remember correctly, I think I mentioned clearly that I never had personal alterations with the PP. Whatever that I had, it's allegations that were people were saying about her in general. So I couldn't qualify them and come here and give evidence about allegations that were made in general.
Yes. No, fair enough. But you see, what I pick up is a kind of contradiction, if for lack of a better word, in that approach, because I've found that in certain instances you put something as a certainty when it clearly should not be, because it was either secondary information from somebody else. And then where you were actually involved, then you put it as an uncertainty. So I'm not quite sure. I'll point those examples out, but do you have any comment to make as to whether that observation is correct or not?
I wouldn't know unless if maybe you take me to specific information. But in as far as I have tried to refer to anything that I was actually involved, to refer to it directly. But if I was not actually involved, what I did was to make sure
to qualify. Yes, and that is because as a legal practitioner, you understand the importance of making it clear when you are relying on secondary evidence and when you are relying on direct evidence. I mean, if you look at paragraph 2, which is the standard paragraphs in an affidavit, it says the contents of this paragraph 2, that would be 2758, Chairperson.
Okay, you can read it.
Yeah, it says the contents of this affidavit are, to the best of my recollection, true and correct and fall within my personal knowledge, unless otherwise stated or clear from the context. And I think that's what you were trying to achieve by making it clear from the context when it's just a perception. But I'm just saying that in certain instances, you don't seem to follow that rule. Maybe let me assist you with an example.
Okay.
On something, because you see, if it's something unimportant, I overlook it. But when you do it with something that might be important, then it might be misleading to the committee. And I'm not saying that was your intention. Go to paragraph 36 at 2769.
Yes.
Now, it is true that the PP has never told you about Gupta leaks, correct?
Yes, that's correct. That's correct.
And
I've never had a discussion with her about the Gupta leaks.
Gupta leaks, yes. And whatever information you might have heard regarding the Gupta leaks was something that would have been told to you by somebody else, correct?
Yes, that I would have got it from a secondary person.
Yes.
Rather.
But now, I'm sure you still remember your legal drafting lessons from your pupillage.
Yes.
Now, if you read that paragraph, doesn't it give the impression that this is something that you are a primary witness to? Let's read it together. You say, Mr. Ndo's email correspondence referred to the Gupta leak emails. That is a reference to that email of NR1. You remember that one, where you were basically being given your broad mandate of the task team. You remember that?
Yes, I remember the email of November 2017.
Yeah. Then the second sentence, that's the one that worries me, and I want you must qualify it if you want, or redraft it, as they say. You say, however, the PP was adamant that those should not be included in the investigation. What's wrong with that sentence?
I think to take to come to your interpretation and what to what you have referred to earlier. What is wrong in this statement is that I didn't put it as if it's a secondary statement. Yeah. Like like you said earlier.
Yes. No, that's fine. No, at least we agree on that. So you'd agree that a reader of this affidavit would think that you are making that statement yourself, because, I mean, especially when you use words like adamant, it would make it seem that you were a primary source.
Yes, that's correct.
But that impression would be false, correct? It would be wrong. I'm not saying you are intending to mislead, but it would mislead an innocent reader who was not part of this, correct?
Yeah, it can, but in any event, I wouldn't want to argue it like a lawyer to say that anybody who has read the context of my affidavit and also listened to me explaining will be able to reach the conclusion that you are reaching.
Sorry, can you repeat that?
I'm saying anybody who listened to to me giving evidence to this committee, and who listened also to you when you posed the questions that you posed earlier on, will be able to determine or to completely say that that statement, the manner in which it's placed in the affidavit, it is misleading.
Thank you. But no, that's fine. Oh, sorry. You can finish.
No, it's fine. It's fine. I don't think it's necessary for me to
continue. Okay. No, thank you. Fine. No. I just wanted to clear things like that. I mean, I'll take you to. There'll be one or two other examples as we go along. And I'm doing that. I'm saying that having complimented you where you deserve it, because you have watered down certain information where you wanted to convey clearly that this was either your impression and so on. And of course, you know, as a lawyer, that your impressions and all that as a witness are not really, don't carry much weight, correct?
That's correct.
All right. Okay. All right. Now then, okay. Now that they've got that behind us, let's just get to some of the preliminary issues. Your view is that you were being victimized because you are a member of the union. Where does that come from?
That comes from the fact that myself together with other leaders of the union, Advocate Matlawe and Advocate and Mr. Kekana.
Yes.
What will entirely happen to Matlawe will then in the following day happen to me, and then eventually happen to Kekana. But like I said in my affidavit, that I never had a personal fight or personal alterations with the PP. So whatever that I might have heard about her feelings towards me, it might have been something that I heard from secondary people, which is not something that I can put here as a direct evidence that to say that the PP didn't like me of 1, 2, 3. Because in as far as I remember, even on my last day, we were in good terms in terms of speaking.
Yes. I see. Who told you that the PP didn't like you?
I would have heard in the corridor, but it's not something that it's not something that I would like to sell over to this committee or to make the committee believe or there was something like that. But what was happening to us as members of the union, what will happen to Mr. to Matlawe, like when these files were taken away? I don't know whether it was the PP's instructions or somebody who is in the higher echelon of management determined decided to take the Matlawe's files, and then it was mine the following day. And then Mr. Matlawe was charged, of which he was not charged by the PP, he was charged by the CEO. And there was that trend. That's what I was trying to say. There was that trend that whatever happens to one member, one leader of the union will happen to another one. So I never wanted to sell that there was that impression that the PP did not like me.
All right. Okay. Okay. But okay, let's come to this. What happened? When you say what happened to one member would happen to another, like an injury to one is an injury to all, I suppose, as they say in the union movement. What happened to Mr. McCown?
Mr. Matlawe's files, there was an investigation concerning the FSB. I think it has changed its name now to Financial Service Sector Conduct or something like that. And that investigation was reported by, I think, Mr. Floyd Shibambu. When Mr. Matlawe was busy with the investigation, it was taken away from him, and the files was just taken away without any explanation. And lately, upon his exit, me and Mr. Matlawe, we both serve our what we call this, our notices on the same time. He was abruptly taken out of the office and told, and he was charged and suspended by the CEO. So generally, as a person and also being in that office, I felt that something like that could happen to me because my files were also taken concerning the SAA investigation. And eventually, when Mr. Matlawe and myself left the office, Mr. Kekana was then charged and subsequently dismissed. And both the three of us were leaders of the union.
I see. So, and were you ever charged?
No, I was never charged. I was only given a letter to explain why charges should not be brought against me. And
the so-called
Audi letter. Yeah, it's an Audi letter. So what happened to me, I don't want my name to be dragged into mud. Hence, I had decided to quit while something like that has not happened to me. Because to have a record like you have been dismissed somewhere, something else.
I see.
Rather than for you to quit.
Yes. So, all right. You are aware that each person who was charged, that they had, there were investigations, independent investigations, and those disciplinary hearings were chaired by independent external advocates like you.
Yes, I'm aware. I'm aware, but I don't. I'm not aware of Mr. Matlawe and Mr. Ndo the thing, because I think they left before the initial charges were the initial disciplinary hearing were concluded.
Yes, I'm sure they did, yeah. But what does that tell you? Does that mean that they were quite confident of their innocence?
I don't know. I don't know. I really, especially when it comes to Mr. Kekan, I heard he was charged for disclosing certain information to the union. And with Mr. Kekan, it's even before that email which led to his demise came through to his inbox. Mr. Kekan, I think he should have been a target, because Mr. Kekan was involved in the completion of that APSA investigation, which the APSA investigation, Mr. Kekana was involved into compiling the Rule 53 record, the one that need to be filed when the review is underway, which was then submitted to court and also to the opponent. So one of the reasons why the court on that judgment, on that APSA judgment, the court found that the public protector should pay cost de bonis properis. It was that the public protector ought to have relied on the report of an economist. And also, she failed to disclose that she met with the president, she met with SSAA prior to her finalizing that report. And Mr. Kekan, I don't know whether he did it deliberately, but when he compiled the Rule 53 records, he produced a note of the meeting that happened between the public protector and the president, and also that SSA meeting. And I think he also somehow the information regarding about the report of the economist comes from there. So for me, I think his main thing that the main thing that Mr. Kekana was targeted for is for the completion of that Rule 53 record.
I see.
Although some of I don't deny Mr. Mpofu that the next what happened to the email and for him disclosing is something else that I have no knowledge of. But I've heard about it when people were talking and when you were cross-examining him that day.
Oh, you were watching?
Yeah, no, I just heard it on news somewhere when I was coming back from the chambers.
All right. No, okay, let me assist you. Mr. Kekana himself admits that he distributed information that belonged to somebody else. So you would agree that that conduct, no reasonable employer can leave such conduct unattended to?
Yeah, like I'm saying, I really didn't know what was the content of the email, but I heard the email was not him; it was directed to someone else. It's just that they happen to have similar names, and for him to have distributed it, it's something else. It depends on what the employer will think about it, because it also. The employer will have to determine the level of prejudice that it has suffered as a result of him distributing the email.
Yes, and again, as a lawyer, you know that prejudice is described to include potential prejudice. What do you think somebody working in such a sensitive position, if they are prone to distributing information that is confidential and is not intended to them, do you think that's a good quality to have for someone who works for the public protector?
It depends because on where you are working. When we were at the public protector, we were dealing with investigations. That's the main thing that we're dealing with. And for me, like for example, for an investigator to distribute such an information relating to investigation to external parties or to discuss investigations externally, that should be viewed as something serious, because that such a person would have signed a confidentiality agreement when you came into the office. There is that form. I signed one myself when I
yourself.
So no, the information that the information that Mr. Kekana is accused to have distributed, it was not supposed to be seen by him. It was supposed to be a confidential information internally within the institution, because a person who works in finance, there is confidential information that should not go around the organization, especially if it's something that has to do with somebody's salary or the expenditure that is being paid somewhere somehow. It should not go to an investigator.
Okay, I think let's round it off like this. Would you agree that it is incorrect or untenable for anybody to suggest that an employee was being targeted, as you do, without knowing exactly what they did or what they admitted to or what they were found guilty of? It's just as a general statement.
It depends, but then the most important thing, you must take into account the nature of the charges that is being preferred against that person, whether those charges are trumped up or it's something that is of a serious in nature. Then you can conclude whether that person was being targeted or not being targeted.
Yes, I agree. But sorry, I agree with that. And also but now that you and I have agreed that in this context, what he was charged of was serious, you would agree, therefore, that it's not trumped up, neither was he being targeted, correct?
I really don't want to agree when I didn't see the email that he distributed. I was in the union. I was not. The email was not sent to me. I didn't see it. I heard that people's laptops were confiscated and mine was never confiscated after that email.
Yeah, that's fine. So since you've never seen the email, you can't make up your mind whether it was serious or not serious, correct?
Yes, I can't come to that conclusion whether Mr. Kekana was targeted or not targeted. But what I do know for sure is he was eventually charged and dismissed.
No, that's fine. No, that's okay. We agree. So you don't know whether he was targeted or not. And Mr. Matlawe, do you know whether he was targeted or not, or whether there was a legitimate issue also in this case?
I don't know what was the charges preferred against Matlawe. What I know is Matlawe was dragged out of the office and told never to set his foot in the office. But Matlawe was very outspoken. Even the person who dragged him out of the office, when he was appointed, Matlawe made a comment in a staff meeting that this person is facing a disciplinary hearing for wherever he's coming from. So it is possible that he might have been charged. But again, as I did not know, or I don't know context of Mr. Matlawe's charges, I'm not in a position to draw a conclusion if he was targeted.
Okay, and okay, fine. So that's another one where you don't know. Mr. Ndo, and do you know what he was charged with? Or?
Yeah, Mr. Ndo was charged, I heard, with sexual harassment. And it is quite a serious charge. Me and you know that sexual harassment it's a serious, it's something serious.
Yes.
But what if I can give you a brief background? The person, the alleged victim of Mr. Ndo, that lady was employed as a provincial provincial representative in Mpumalanga. We
Okay,
received
hello, sorry. Whatever you do, don't mention anybody's names. Yeah, you can just talk.
I won't mention a name.
Okay.
We received numerous complaints against the provincial rep of Mpumalanga as the union. Early back when, during the times of Professor Madonsela, which we raised with the management about the management style, the hierarchical management style, and also what we call, she will just stand in the corridor and ask people to go and sit into there's a whole lot of complaints, which we took on with the union, whereas the union with the management at the particular time. Then they came, there was a period when these provincial rep swaps, they swapped the positions, they moved from one province to another. And she moved to Gauteng. Again, when she moved to Gauteng, we received similar problems. But what we have had, Mr. Ndo was initially suspended and he was investigated by an independent panel. And the suspension was lifted and Mr. Ndo came back to work. What I really don't know is what influenced the charges against Mr. Ndo to be brought back towards the end of 2018. Because we thought the issue relating to the charges and the complaints relating to the complaint from that particular victim was then cleared. But from our observation, I wanted to just, from our observation as the union, we thought maybe the complaints against Mr. Ndo were just being brought in order to tarnish or in order to deal with the fact that Mr. Ndo was at some point trying to address the complaints that have been raised by staff against that particular person, because Mr. Ndo was that particular person's manager. But I don't really want to comment about the merit of the complaints itself.
No, but that's what you've just done. So you're saying she was not, you are denying her harassment. You're saying it was
I'm not denying him. I'm not denying it. It might have happened under the circumstances which I don't know what was happening between her and Mr. Ndo. But for me, I'm saying when it's also possible that when Mr. Ndo was addressing complaints against her, she decided to see it as a best time to complain against him.
So it's not, what are you trying to say? So it's not possible that he could have been investigating against her, but at the same time, he harassed her sexually.
It is possible
why are those two things mutually exclusive?
What I'm saying, it is possible that the incident that she referred to of sexual harassment happened, and she did not report it at a particular time when it happened. She only reported it when Mr. Ndo was investigating complaints against her from staff members in Mpumalanga and staff members in Johannesburg.
Oh, I see. So is there a time limit to reporting sexual harassment against yourself?
There's no time limit.
Okay.
But what I wanted to say is we must also look into the reasons for one reporting a certain act after some time. So what I'm saying, I'm just explaining to the committee, it's the complaint against Mr. Ndo might have something that is brought as a result of vengeance or something.
I see. So we blame the victim. So it's like saying she was wearing a short skirt, something like that.
No, I'm not blaming her. I will not be a real man if I blame the victim. But I'm just
But
questioning the
vengeance-
timing.
Okay, so vengeance is not blaming.
No, I'm just questioning the timing of her reporting the complaint and the fact that the complaint was dealt with by an independent body, and the timing of the complaint being reinstated or the charges being reinstated against Mr. Ndo towards
Okay,
his ex.
well, that's fine, Mr. I think we get the picture now where you come from with this testimony of yours. All right. Now, you say that the other reason why you were targeted is because you worked with former public protector Madonsela. Where does that come from?
Again, let me go back to our discussion when we started this cross-examination, that I don't want to put it on record that I was targeted, but one of the reasons that people were talking about things, they were talking about people who worked with previous public protectors so closely were not favored under the new regime. These are the things that we heard on the corridors, but I really don't want to put that as a primary, as a direct evidence to say that no, I was targeted because I did what. I was just saying that one of the things that I thought, this is how I should have put it. I should have said, I thought I might be a target because of because I was involved in the union, and also I used to work closely with Advocate Madonsela when she was still at the office. So, and like I said previously, what was happening to my colleagues who are leaders in the union, it might have happened to me as well. I don't know. I don't know about that, but it didn't happen. I left before that happened.
I see. Okay, so what do you really mean by that, given the facts that we've discussed, is that if you had leaked sensitive information, you might have been charged, because that's what happened to Mr. Kikan. So what's wrong with that?
No, there's nothing wrong. If I have done something that was warrant me to be charged, then I was obviously going to be charged, because I was not prone from being charged like any other employee in the organization. Yeah. So obviously, if I had done something prior to 2019, or when I answered that Audi letter, I didn't advance certain reasons which might be acceptable, maybe I would have been charged. I don't know.
Yes, no, but exactly that's where I was going next, because before we leave this whole conspiracy theories, so if your evidence is that you were given an Audi letter and you gave an explanation of whatever you were being accused of, and then it was fine. Nobody charged you after that, correct?
Yeah, nobody charged me after that. And I don't know where the letter was coming from. Who was the initiator? Whether it was the PP or it's somebody or it's my immediate manager who thought he might write it to me and said he was instructed above that he must write the same letter. I don't know. I wouldn't tell.
Mr. Raidan, you love conspiracy theories. So, okay, let's say then it was the PP and then it went through some channels and all that, yeah. But you were not charged?
No, I was not charged.
Yes, so would that then be the actions of a PP who was targeting you? Let's say she targeted you in this conspiracy way that you are defining, and then you gave the explanation. If she was targeting you, she would have charged you anyway, isn't it? Even if you gave a good explanation.
That's why I'm saying I don't want my evidence to be recorded as I was being targeted.
Well,
But
the problem
what I
is
have
that.
seen,
Carry on, sorry, Mr. Duche. No, I'm saying, okay, sorry. Can we just do it like this? Please give me answers to, I don't want to stifle you, but it's going to take too long if you give long answers. So maybe I'll try to lead you. So your evidence is that you are not being targeted.
my evidence that as it appears, I might have thought under the circumstances that I was targeted because I was a member of the union. I had close relationship with Professor Madonsela, and there was a saying that whoever was close to Professor Madonsela is not supposed to be close, it's not favored under the new administration. But my answer is quickly simple. I don't have direct evidence that I was either targeted by the PP or any other person.
Good.
I might have thought so before I resigned, but I don't have direct evidence.
All right, so we can at the very least, can we accept that this might have just been the product of your imagination?
I don't know what to call it, Mr. Mpofu. So
well, that's why I'm giving you a leading question. I know what to call it. It's conspiracy theories and fertile imagination, but I'd like you to tell me what you call it.
So, like you said in the beginning of this, for me, I will say my convictions was influenced by maybe secondary information that I've heard from other sources, which is not a direct evidence that I had.
Yes. So the committee must then not place much store on that particular aspect, correct?
I think that would be the view that the committee will take itself, considering the evidence that I have given.
Yeah, if you were a member of the committee, would you agree that it should not be taken seriously?
I don't know. I'm not a member of the committee.
No, I know, but I'm saying just for a minute, assume you were. You are a lawyer. You could have been a member of some panel that is dealing with this. Would you take yourself seriously? Would you take, that evidence that you were being targeted seriously?
I'm not a member of the committee, and I have not been called upon to determine whether certain evidence that is being given, I should consider it. If yes, I was sitting in let's say I was a chairperson of a disciplinary hearing, or I was an acting magistrate or something, I would have obviously placed I will have my views on the evidence that is being presented before me.
Okay, let me assist you again. Your views would be that the evidence is highly unreliable. Am I right?
I really don't want to agree with you on that one. I might be persuaded otherwise once you are not persuaded otherwise as well.
No, that's fine, Mr. Advocate Rodan. All right, and then I think the same applies to your alleged professional disagreements with the PP. Just to round off that topic, we should take it with the same pinch of salt, correct?
We disagreement professionally, Mr. Bof, it's when we are lawyers and we are, especially where we are called upon to make contributions, especially in like the nature and or the conditions that we were under at the public protector. It's professional disagreement is something else. I think it should have been placed to say that we might have had different views, which is not the same view that the PP might have shared at that particular time. Like, for example, when you look at an investigation, when you look at a particular investigation, I might have my own view as a lawyer. and also depending on the experience that I had at that particular time in the Office of the Public Protector. And I will, based on my experience, my knowledge, and my understanding of the matter, I was simply going to have a view. And that view doesn't necessarily mean to be the same as that of the Public Protector. And it might not be the same as that of another investigator. Or I can share a view with other investigators, which the Public Protector does not agree with. And as a legally qualified person, she is entitled to that. And it doesn't make my view less than that one of the Public Protector.
Yeah.
So if we differed in opinion, we differed.
Yes. No, that, I agree. I also have professional disagreements with my juniors and colleagues here. So that you're right, that happens. That's the whole point of having more than one mind in a team, isn't it?
Yeah, that's in fact, that's why we had the issues of think tank, and we had committees where we sit and deliberate on reports. And
Okay.
then at the
So
end
you
of the
wouldn't
day,
So you wouldn't rank that as another reason why you are being targeted, the so-called professional differences, because that happens all the time, correct?
No, I don't think a person can be targeted because you differ with views, especially in terms of the work that you are all employed to do. So that
Yes.
that I don't think that I can say but people can differ in any environment when it
Yes.
comes to the work that we do as lawyers. That's why maybe when parties don't agree, they go to court they take their disagreements to court.
Yeah, no, that's fine. Let's not go down that road. The evidence of Mr. Tebele was that, yes, even he would have differences of opinion with the PP, but she was welcoming to that. And that, I think that was even the evidence of Advocate Chualule, but that she was not taking those personally. So it looks like you agree, because disagreements always happen in the workplace at that level, correct?
Yes, no, it has. We have had several engagements with the PP, whether we're sitting in a meeting or whatever. I have expressed my view in certain investigations that were being and sometimes she has listened to me. Sometimes she has disregarded those comments, and she had accepted other people's views as well.
Yeah.
But ultimately, like I said, she's the one who will take the final decision on the matter.
And you accept that?
That's the nature of the office itself, because she did,
no, that's fine.
like.
Yeah, no, that's fine. You see, the problem, Mr. Advocate Raidane, is that you have given, that's why I started like this. You have given certain impressions which are either false or which you are ready to disown as soon as we discuss them. So you did not, you disown the Gupta Leaks story. You disown the issue about the union and the targeting, that you are not being targeted. You've now disowned the issue about your relationship with Professor or Advocate Madonsela. And now you are saying that the professional disagreements are par for the course, which is true. But go to paragraph 15 of your affidavit. Anybody reading that would think that we're talking to, they'll be asking, where's the real Advocate Raidane? Because there you say the evidence leaders asked me why I would be a target, which you obviously had claimed to be. In my view, I was a target because of my involvement in the activities of the PSA, which you have already disowned now. My professional disagreements with the PP, which you have already disowned now. and my own good working relationship with the former public protector, Professor Madonsela, which you've also disowned. So what must we believe is the issue, is the real issue?
I like to be, you are saying I disowned. I never disowned this.
Okay, you are re-owning. Okay.
I'm saying I might have been a target because I was involved in the PSA, in the union, which the union was known to make noise in the organization about certain issues and to disagree with management when it comes to some issues that the members of the union will complain about in the organization at all. Then again, I did not disown that. I said, by the mere fact that you are in the union and what I've seen was happening to my colleagues in the union. So, and like for the fact that an investigation was taken from me, which I was doing, and it was taken from Matao. That's what I said. Maybe I thought we were targeted because we were part of the union leaders. I never said I disown. What I'm saying is that irregardless of some of the things that I've had, especially when you talk about when you talk about the things that maybe the PP sort
professional disagreements, for example.
Yeah, maybe the PP viewed me as somebody who was closer to Professor Madonsela. I have never heard the PP saying that from their mouth. What I'm saying, there are people who are close to the PP who will go and attend meetings with the PP and come and tell us those things. But who am I to question the credibility of those people who are not even witnesses? So I'm really finding it difficult for me to come here to the committee and say, no, Advocate Mukwebane did not like me because of this, because I've never heard her saying that. And I cannot rely on people, on information that I've heard from people, especially because it's hearsay on its own, and make effect here.
All right, sir. Thank you. So are you sticking to the idea that you were targeted because you had professional disagreements with the public protector, or are you disowning it?
I'm not disowning it. I'm saying the manner in which
are you justifying it then?
I've expressed it in my affidavit. It should be taken in that context.
Well, what about? Okay, finish.
No, it's fine. I'm done. You can ask.
I'm saying, okay, sorry, sir. I didn't mean to interrupt you. You know, Advocate Raidan, it's important for you to give truthful evidence so that we know where to place your evidence. I've just had a discussion with you before I showed this to you on paragraph 15. You and I agreed that the issue of professional disagreements was not a non-issue because it happens in every workplace. It could never, you even said you could never use that as a ground for being targeted. Now I show it to you on paragraph 15. After you disowned it, now you are re-owning it. Which is which? Is it an issue of professional disagreement? Is it natural in a workplace and therefore a non-issue which can never be a reason for targeting, or is it?
It depends.
Both statements, sorry, let me just finish. The problem with that, as you know, is that both the statement you made that professional disagreements are a reason for being targeted, and the one you made that professional disagreements cannot be a reason for being targeted. Both of those are made under oath, because you made an oath when you were making the affidavit, and you've also made an oath this morning here. So which one is the truth?
The truth is what is written in my affidavit, and which I'm going to.
The one you just said earlier.
Let me repeat it. I never disowned the statement. I am agreeing with what you are saying, because what I'm saying it's one, professional disagreement. It happens everywhere. And then if I were to qualify that, it depends on who the person you are disagreeing with. How is that person going to take it? For example, if I say I advised someone, I told someone that this report is going to be reviewed, and it's get reviewed, and that person take it personal, that's something else. But if the person doesn't take whatever that we say personally, then that's when professional disagreement, it becomes a non-issue.
That's fine.
So what I was actually saying, I viewed it. Those were reasons that I viewed. I might have been now fell out of favor of Advocate Mukwebane.
Okay, thank you, sir. That's very helpful. Yeah. Thank you. Okay, now let's go to the issue of the report, the further report, because I think that's probably where you were supposed to be assisting us here. Is it your evidence that the findings of financial misconduct were removed from the report? I thought I heard you saying that you agreed to that when it was put to you by Advocate Bauer.
Yes, I agreed to it when I saw the two versions of the report. It
was long before that. It was before lunch, actually.
Before lunch.
Yeah.
Okay. Now you can proceed with your question.
No, I want to know once again, is that still your evidence or are you changing?
Can you repeat the question?
Is it still your evidence that the allegations or findings of financial misconduct were removed by the public protector?
I'm just checking my document. I don't know.
No, don't check anything. You didn't. You were asked the question and you said yes to Advocate Bauer. You didn't ask to check any documents. Is your answer still the same?
No, it's still.
Pardon?
Still the same.
Still the same. Okay. All right. Now you might want to check your documents now. All right. So do you know that the public protector, or rather, let me put it this way. Did you see the Accountant General's investigation?
Yes, I saw it, but I didn't read it recently. I read it 5 years back then when we were working on the report.
Okay. And do you agree that the Accountant General made findings of financial misconduct?
Financial misconduct. As far as I can, because I haven't seen that report recently, but they did make findings of financial misconduct.
Yes. Okay. And the public protector agreed with that, correct?
Yes, she agreed with that. I think she accepted that. That was my evidence that she accepted the report of the Accountant General.
Yes, in fact, the word she used was that she was in concurrence with those findings.
Yes.
Of financial misconduct, correct?
Yes.
And at 6.1.4.2, which is the 1269, she also said that the payments to Estina were also not in line with Treasury prescripts. You know what those are, correct?
Yes, the payments that were made as contribution by the Department of Agriculture to Estina.
Yes, if payments are not in line with Treasury prescripts, do you know that they amount to financial misconduct? I'm sure you'll agree with that.
It depends on what context, because if payments were made to a party, to Estina, and you want to call it a financial misconduct, you can always call it financial misconduct if you want, depending on how you are going to.
Yeah, I want. All right. No, that's so okay. And then if you go to 6.1.4.4, it says that despite the Accountant General's report, which you say you read 5 years ago, the department failed to comply with Section 81 and 86 of the PFMA, which prescribe the process to be followed when there is allegations of financial misconduct. So now it's clear that she was agreeing with the findings of financial misconduct, correct?
Yes, she was referring to financial misconduct.
Yes, and she was concurring with those findings, correct?
As it depends, like on how you will interpret it, or whether she was. But I think my evidence earlier on, if I can just clear, it appeared that there was a specific finding, which says whatever that the head of department did amount to financial misconduct, and that part that says financial misconduct was then taken out. And I don't disagree with the manner in which you are interpreting financial misconduct under these circumstances.
Okay, but then
but that particular finding from the earlier.
Okay, no, carry on. No,
So
okay, so you're allowing me to talk. Okay. I'm saying, Mr. Raidan, one cannot agree with both you and I. So it's either you agree with me or you disagree with me. Because your version is that she took out the financial misconduct. My version is that she didn't. So you can only agree with one of us. Which one? Do you agree with me?
I don't expect us to agree, especially when it comes to interpretations of what is written down in a plain language. Because
so when you said you agree with
I agreed to the fact that I'm saying I agreed to the evidence, to the information that the particular findings which says financial misconduct, which says the act of the HOD constitute a financial misconduct, or the act of the department, was removed from the earlier version of the report, was in the earlier version, as it was in the earlier version of the report, was then removed. And it is not there in the final version of the report. So what you are suggesting to me is that the public protector does not do away with the issue relating to financial misconduct. She does refers to financial misconduct in some of her findings, like for example, the finding regarding her concurring with the report of the Accountant General, and the finding that you just referred me to now on the final report, of which I don't disagree with you, but I can't agree with you. What I was testifying on is about the particular finding which was removed from the report.
Okay.
Thank you. Just a pause before Advocate Mpofu. Mr. Raidani, Advocate Decheni, just you're thinking, just reposition yourself because we're only seeing the face now and you're going down. We don't want you to sink. Please. Can I allow you to just reposition yourself, just lift yourself up in that video? There you go. Thank you. Go ahead, Advocate Mpofu.
Thank you, Chairperson. Yeah, I'm also having that sinking feeling. Thank you. All right. So, Advocate Mbicheni, sorry, you say you don't agree with me, but you agree with me. I don't know what you're saying. Which is it?
I don't agree with the fact that you are saying I'm wrong when I say Advocate Mukwevane removed a financial misconduct from the report. What I was saying, I'm saying there was a particular finding which says that act of the particular official or the department amount to financial misconduct. I'm saying that part was removed. And you are bringing in a version that says, no, the public protector does not do away with the financial, the finding, with that finding of financial mismanagement. She actually concur with the report of the Accountant General, which refer to that finding, which found that amount to that. And also in one of her findings, she does deal with those are your version. I cannot dispute it because what you are saying is correct. What I'm saying, on the other hand, it's about the removal of the actual paragraph.
Okay, and I think I understand. So what I'm saying is correct, but you disagree with me. That's your final answer.
I don't disagree with what you are saying. I disagree with you saying that I'm sticking on with the version of my evidence. My evidence was that she removed that paragraph. And you are saying, no, she didn't actually remove it. She dealt with the same aspect of financial mismanagement under different paragraphs. And it seems as you are pointing me to something that maybe I never thought about.
Yes, no, that's fine. Okay, now that you've thought about it, would you agree that your answer to Ms. Bauer was incorrect?
I wouldn't say it was incorrect. It might have been correct under the circumstances that I was answering, which was in relation to the removal of the particular paragraph. Okay, but in the context of what you are saying, it might be viewed to be incorrect.
It might be viewed. Okay, that's fine. I think I can live with that. All right. And do you know what that's sections 81 and 86 of the PFMA? Okay, it's not a trick question. Those are the sections that deal with criminal conduct for breaches of PFMA. Are you familiar with that?
Yeah, but I cannot tell you what is the context of the particular sections.
No, no, that's what I'm saying. I don't expect you to know it off by heart. I'm just saying that that's the part of the PFMA that deals with criminal liability. If you know the structure of the PFMA general, if you don't know, you don't know. But I'm telling you that that's what it is. And therefore, do you understand? If I'm correct, do you understand that the level of misconduct?
They've just disconnected.
Oh,
it's just the two of you.
Mr. Advocate Raidan. How are you?
I'm fine.
Are you still fine? Oh, you're still fine. Okay, apparently we are just talking to each other. Everyone has just been switched off. So unfortunately, we'll have to do this again.
Yeah, I'm fine. Yeah, I've seen from panel. No, okay, I'm just I just received a call.
Okay, that's fine. Of course, apparently it's just you and me. So let's just wait until we reconnect with everyone. Okay.
Since for the past 5 minutes, they couldn't hear.
And they missed the best part.
They missed the best part. They said they can see you talking to each other, but they can't hear it. They miss the best part.
Yeah, no, it's fine. We'll,
apparently we are going to be back at 15:40.
oh, I see. So there's a break.
Yeah, there's a
Okay,
break until 15:40.
Sure. Okay, fine. Let's come back at 15:40.
We can sign off.
Okay.
Sure.
the cross-examination. Please proceed from where you left off with Mr. Raidani.
Yes, Chairperson, I'm not sure at what point I left you. Was that before, just after Mr. Raidani was thinking?
You left us when he fixed himself on the seat, and then you also sank. And then that's when we lost you.
It's infectious.
But before you proceed, I see a hand of Advocate Bauer. Advocate Bauer.
Chair, if it may be of assistance, Mr. Mpofu was asking the question on the issue of financial misconduct in the version of the final report, as to the evidence that was given before the lunch adjournment. And whilst we come in on that, I just wanted to, on a point of correction, say that the reference to the financial misconduct that I referred to before the lunch adjournment referred to EE on page 1219 of the final report with reference to 3069 of annex to Advocate Radani's affidavit.
Okay, thank you for that. Over to you, Advocate Mpofu.
Thank you, Chair. Okay, thank you, Advocate Radani. Can you assist us just where it's possible? Just give short answers, and then we'll move faster. Okay. Okay. I'll try to give you leading questions so that it makes it easier for you. We were still on this issue, and I was getting even more confused before the technology intervened. Whether it was before lunch or whatever, you accept that you said that the public protector removed the findings on financial misconduct, correct? You said that yes. to the evidence leaders, yeah.
Yes, I accept that, and I was making reference to a executive summary of the final report, which is paragraph number EE on, I think it's 1218.
Yes,
on page 1.
Yeah, that's fine. And you are agreeing with me when before you were interrupted that in actual fact the public protector concurred with the findings of financial misconduct that were found by the Accountant General, correct?
Yes, no. You put a version that the public protector did not deviate from the issue relating to the financial misconduct, because that the financial misconduct was referred to in the Accountant General report, and she also referred to in some of her findings in the final report. What I actually agreed to when I agreed to Ms. Power's question was that such paragraph EE of the report, which says that the accounting officer of the department proceeded after the recommendation of the Accountant General to pay further 149, which was in that paragraph earlier on. That paragraph, when it ended, it also referred to it as a financial misconduct, as that amount of financial misconduct. I'm saying that was removed from the earlier version of the report, and it does not reflect, is not reflected as it is in the final report.
Okay, but you agree that the findings of financial misconduct are contained in the public protector's report?
I will accept your version that the public protector continued to refer to the financial misconduct. I'm saying
it's not a version. I read it. That you accept what I read from the report, not my version.
Yes, I accept what you read from the report.
Okay, thank you. All right. And therefore, any impression that the public protector did not or did not make findings of financial misconduct, as I was trying to demonstrate to you that it even refers to the PFMA, which is on the criminal conduct sections of the PFMA. That's even more serious than normal financial misconduct. Do you agree?
Yes, I will say now, the impression that the public protector made reference to financial misconduct is clear in those two findings in the final report. But I don't think the intention of Ms. Bauer when she led the evidence, she wanted to I think I don't know what she wanted to.
I don't know what about the intention of Ms. Bauer. Let's just stick to the facts, please.
Okay.
Okay. All right.
It's fine. You can proceed.
Yes. Okay. So whatever the intentions or non-intentions, we at least let's move on now. We agree that the financial misconduct findings were made and they were serious, of the more serious nature as referred to in the PFMA, correct?
Yes, depending. I agree because she makes reference in her findings. She makes reference to the financial misconduct.
Yes, thank you. All right. Now, as far as another correction or unqualified statement that you make, which could be misleading as well, I just want to just recap on the theme that I started with here. Can you go to paragraph 73?
73.
Yeah.
Okay, yeah.
All right. You say that in 6 months, the portfolio committee raised concerns about the report and requested the PP to consider the role of politicians in the Friday matter. Shortly thereafter, the PP instructed me. Was that a slip of a tongue, or did the public protector instruct Mr. Ndo or someone else?
It was not. I was told, Mr. What happened naturally in the public the public protector can write in a specific document to say, Mr. Raidani, do this and this. Or sometimes she passed the message through your relevant managers when they are reporting. But I remember in that instances, there was an instruction directly from public protector that I should reinvestigate the matter. And hence I will qualify that to be coming to the fact that the public protector at that time, she in her head, the last person that she worked on Friday investigation was me.
Are you there?
Yeah, I'm here, but it seems as Advocate Mpofu. It's muted.
Advocate Mpofu, are you there?
Yes, I'm here, Chair. Sorry, I think yes, I'm here, Chairperson.
Go ahead.
So did you hear my last? Did you get my last question, Ms. Advocate Dan?
Yes, I was still on the answer. You were asking me to give you clarity on the paragraph 73.
Yes, no, I was saying if she says she did not instruct you directly, will she be wrong?
I don't know, Mr. Mpofu, because I wouldn't recall how the instruction. But obviously, if it didn't come to her, it's through her. If it didn't come from her, it came through Mr. Ndo.
Okay, but again, you'd agree that anyone reading this would be forgiven for thinking that she instructed you directly and you were sure about that. You are not saying, it's not one of those where you say to the best of my recollection. You realize that?
Yes, and again, I will say that depends on the context. If somebody's reading this alone, can simply think that that was the literal instruction being given to me when we sat with the public protector and there was no other person. But if somebody's reading in the context of an office where there is a hierarchical management, then obviously with my explanation can qualify that statement.
Yeah, Mr. Rajan. I think, yeah, honestly, I don't know. All right. Now talking about hierarchy, you accept that you basically you reported to Mr. Ndo.
Mutupi.
To Mutupi, yes. And Mr. Mutupi reported to Mr. Ndo.
Yes.
And Mr. Ndo reported to the public protector.
Mr. Ndo reported to the CEO.
And the CEO reported to the public protector.
The public protector. And then you had your deputy. So it was a long, a whole lot of hierarchy. But what eventually happened is, with regard to investigation, you will find that Mr. Ndo report directly to PP. And sometimes, depending on who is working on the matter, I might report to Mr. Ndo and then the PP. Or sometimes it happens, it's you and the PP alone, and there's no manager involved.
No, I'm not talking about meetings, Mr. Redan. I'm talking about reporting
lines.
Yeah, in the reporting line, you were five steps removed from the public protector.
Yes.
Thank you. All right. Now, and Mr. Ndo basically was given a free hand to put up a team. You were not appointed by the PP yourself, correct?
Yes, I was not appointed by the PP myself. It's, if I can recall, and based on Mr. Ndo's email.
Information, yeah. All right. And you can't confirm, you were saying that apart from corridor talk, you can't confirm this notion about purging, correct?
Yes, when it comes to me, I cannot confirm the notion about the PP paging me.
Or anyone else.
There is that corridor talk that you are referring to. And then eventually there are charges as you mentioned about Ugo and others.
Yeah. Okay. I think your evidence is seriously problematic, but let's move on. I'm worried about you. But now let's go to the issue of go back to the Freda report, because I think that's the main issue about your evidence. You agree that the findings about disciplinary steps to be taken by the Premier were retained?
Yes, on the final report.
Yes. And the only issue there was that the public protector said that the Premier must institute disciplinary action against all implicated officials. And you understood that when you guys were drafting the report, you understood that to include the HOD, correct?
Yeah, that's include the HOD.
Yes, and in fact, to your knowledge, the HOD was indeed suspended as a result of the public protector's report, correct?
I don't know, but I heard on news that he's now even facing criminal action.
Yes, even worse. Okay. And do you know the purpose of a Section 7(9) letter or notification, notice?
Section 7(9) letter comes from that particular Section 7(9). Immediately when the public protector comes across information which might directly or indirectly implicate someone, the public protector must notify that person in terms of that section 7.9. So that was the purpose of us then now reverting to section 7.9 letters.
Yes, and you accept that the section 7.9 is like the Audi letter that was sent to you. It's done in terms of the Audi alteram partem rule, correct?
Yes, it's in terms of the rules of evidence. So I hope that the intention of the legislature was to achieve that when they enacted that provision in the legislation.
Yes. Yeah, well, it's not evidence rules, it's the rules of natural justice, but that's fine. The point I really wanted to make is that a recipient of the 7.9 notice is then being given a chance to clear their name or to explain the conduct in respect of which they are being implicated, correct?
That's correct.
Yes. So if the person if they give an adequate explanation, just like you did when you got your Audi letter, then nothing else should happen to them, correct?
Yes, just to come to the section 7.9, if somebody give adequate explanation to a particular intended finding, then we normally remove that from the report if we feel that that finding is no longer substantiated.
Good. All right. Yes, and that's why I'm making the example. It's the same. It's an Audi letter, just like the one you received. You received an Audi letter. You gave an explanation, and you were removed from the suspicion. Correct? Of whatever you are being accused of.
That's correct.
Yes. So, and now the reason why I'm asking you that question is because it's very important to what we're discussing. Because the public protector will say that, or let me start by saying, did you ever read, I know you came late into the Friday investigation. Did you read the historical documents that had developed up to that stage?
I read everything, and what as a quality assurance person, what I should have done under my responsibility was to look at the 7.9, and then I should also consider the answers to the 7.9 letter, and see if what is now left in the report has not, if something has been addressed by the answer to the 7.9 and is still on the report, that should have been removed. So it was part of my duty to ensure that if something was addressed in response to 7.9, I should have removed it. If it remains in the report, I should address it and then remove it.
Yeah, no, perfect. I think, then we agree. And how many 7.9 letters did you look at, or how many had been sent by the stage that you joined that investigation? And
they were initially, there should be 2.
Mm-hmm.
There should be 2, one to the HOD and one to the MC had that. But I remember the one that I can remember. It's the one from the Premier. I had a look at that one, and I also looked at his responses, and I looked into the findings.
And did you look into you said the one was to the HOD?
And one should have gone to the Premier, and the other one to the then MEC, who was Mr. Zwane.
Okay, and you read the one, all those 3?
Yes, the one that I can still remember, I can even see it if I close my eyes, is the one from the Premier.
The others you can't see if you close your eyes.
No, I can't. I haven't. I remember there was one, but the one from the Premier was too detailed, and addressing specific issues, paragraphs, and all these things of that 7.9 letter.
Yes, that's correct. It was actually, if I remember well, more than 10 pages. Correct?
Yeah, it was quite a substantive letter.
Quite detailed, yes. Now, and that's the issue, the central issue, which I raised also with Mr. Samuel, is that what happened is that it's no use to come to a committee like this and say, this was removed, this was not removed. Things get removed either because there was no investigation around that particular issue, or there was an explanation which was given in the course of the investigation, including the Section 7(9) notice. You would agree with that as a general statement, correct?
No, that's correct, and also some internal contribution and comments from colleagues can cause certain issues to be removed from the report.
I see. Yes, correct. In other words, also the internal debate among the team, correct?
Yes.
And that's all this. I don't have to take you blow by blow, but you'd agree that that's all that happened here. There were issues. To draft something or to edit something includes removing things. If you are an editor, or if I'm settling your draft, it might entail removing some of your paragraphs. That's the nature of the business, correct?
Yes, that's correct.
Yes. Now, the issue that I want to put to you is that, so that we save a whole lot of time. The version of the public protector is going to be that is all that happened here. There was a series of information that was added or removed only as a result of the things that you have mentioned. A, internal debates. 2, the responses that were received from the Section 7(9) notices, but also in this particular case of Frede, because other agencies were either investigating a particular issue, and there's always, you have to make sure that you don't get into somebody else's space. As a broad framework of how the process unfolded, would you agree with that?
To be honest, to you and the committee, the public protector is entitled to canvass that version.
Yeah, no, that goes without saying, Mr.
Entitled to canvass, and it's within a legal avenue to canvass that version.
Right.
And
okay, yeah, but it's based. Remember, you are here as a witness because you were there. Neither the members of the committee nor myself were there. So it's unhelpful to say someone is entitled to something. We are more interested in your comment. Either you don't know, or you agree, or you disagree.
My comment is simple. What you are saying, and I agreed with everything that you have put before me. That
okay,
what led to the changes being effected in a document that is being settled are those circumstances that you mentioned,
yes.
Especially when it comes to the reports of the public protector. It starts from the 7(9), then internal debates and all these other issues. So what I'm basically saying, if the public protector wants to put that version through, it is correct, it's legally correct for her to put that version.
No, I think you don't understand. Yes, it's legally correct for her to put that version. The question is, you've already answered the question, is that you agree. That's what's more important for you as a witness, not her legal entitlements. You agree, correct?
No,
correct?
I agree.
No, you agree.
What led to the change? Yes, what led to the changes is what you highlighted.
Yes, thank you. And in this particular case, the changes, as you have explained, were effected mostly before the matter even came to the public protector's desk. In other words, between yourself, Mr. Ndo, Mr. Kekana, Mr. Stole, and Mr. Namasisi sometimes, correct?
But ultimately, the serious the changes which have implications were changed after we have met the public protector on the morning of the 8th of March.
Yes.
And
you mean February?
Yeah, February, sorry.
8th of February, yes, that's fine. Yeah, no, we'll get there, believe me. I'm saying that before the 8th of February, the changes that were made to the various documents, and I can't even keep up how many they were made as between yourselves as in the team and sometimes with the assistance of Mr. Namasisi, correct?
There might have been various changes from the person who initially drafted the report to the supervisor. And then in fact, let's say it's correct that there were a number of changes that the public protector had nothing to do with before the report was sent to her.
On the 8th of February, yes.
On the 8th of, I think it's before the 8th of February, obviously, because that's when she called the meeting of the 8th of February in the morning.
Yes. No, I accept that, Mr. President, that it was not just on the 8th, even the day before or whatever, there were some exchanges. But at least you've assisted me here. Now, you accept that those changes that were made without her involvement should not, cannot be put on her plate. In other words, they would have been introduced by those people who introduced them or as a part of the debate that did not involve her, correct?
Yes, as long as she has nothing to do with the changes.
Yes. Okay, so that's the one part. Thank you. Thank you about that. The second part of that I want you and I to agree on is the fact that you've explained that the changes that were being made were made by people who were in different rooms or even on different floors of the building, correct?
That's correct.
Yes. So you would not be privy, for example, to discussions that might take place between Mr. Namasisi and the public protector about a particular issue, correct?
Yes, it depends on whether I was present when there were discussion. If I was not present, I will not be privy to that.
No, Mr. Ndechen, I'm saying to you, that's why you must listen carefully. I'm saying on those occasions where you have testified that the changes were being made by members of your team when they were sitting at different parts of the building, you would not know what discussions were taking place between Mr. Namasisi and the public protector, for example, which might influence him to change a particular clause. And that goes without saying, correct?
Yes, I wouldn't know unless if I'm sitting with them.
Yes. All right. Now, so when you say, if you say, for example, there's a part, I think it's where you say Mr. Namasisi reinserted a finding after there had been a debate with the public protector. It's possible that they had discussed it bilaterally and then agreed to reinsert it, correct?
Yeah, it's possible.
Thank you. And the public protector, and don't tell me she's entitled to do it because we know that, will say that some of the changes came in that fashion where there would have been a debate in group form, as you correctly point out, but there would also be discussions with individual members of the team. That's obviously something that happens that naturally happens in these processes, correct?
Yeah, that can happen.
Yes. All right. And you've also confirmed that one of the innovations that were brought by the current public protector was to have this dedicated legal office, correct?
Yes, it was in the pipeline, but she's the one who implemented the innovation.
Yes, like many things, yes. Okay, so, and one of the reasons for that office, I think it was your testimony, was to make sure that after all the processes of the investigation, quality assurance, and so on, the report is then filtered to ensure that it doesn't constitute, or rather, it doesn't contain reviewable irregularities, correct?
Yeah, that's correct.
Right. And that would have been a very positive development that she introduced as a public protector, that no other public protector had introduced, correct?
It's if you want to say, you see it as a positive thing, I can take it as a positive thing as well, because it was, you were getting somebody with who was not involved in the investigation to comment, just looking at the legal part of it.
Yes. Yes, thank you. So you agree then that it's a positive, it was a positive innovation on her part?
So if it's a positive innovation, then I will agree that it's something positive that I've seen. I also seen it something. It was beneficial for that third party to have a look at our reports.
I see. Yeah, okay, you prefer beneficial. Okay, I can live with that. Right. And you've already agreed that Mr. Namasisi, okay, so if you think about the evolution of this report then, and again, I'm going to cut out some of the mini stages. So there was the report that was left behind by Advocate Madonsela after the 4-year investigation, where the investigation was unfinished. You knew about that, correct? You knew that the investigation dated back to 2013.
Yes, it's initially, it's in the first paragraph of the report.
Right. And then after that, there was the involvement of Advocate Mkwebane. And then there was at some stage what you call the Kekana version, correct?
Yes.
And then after the Kekana version, there was then what you call the Nemasisi version. That's another stage of the growth of the report, correct?
That's correct.
Right. And then you as a team worked on it, and then it was finally presented to the public protector, correct?
Yes.
Right. Now, so what I'm saying to you is that there would have been various changes that are made. Let's call it the Madonsela stage or the Madonsela version, leading up to what one might call the Kekana version, and then to the Namasisi version, and then eventually to the public protector's version, which is the final report, correct?
No, that's correct.
All right. And see, if you say no, that's correct. The record will show it as a negative, but that's fine. I think we know what you mean. That's how we speak here. Hi, good job. All right. Now, the changes that were introduced you've said you call yourself a quality assurance man, correct?
I was robed to do what we call quality assurance. There was an investigator who was specifically appointed to that post, who was Advocate Matlawe. I was just called to help.
So to help with quality assurance.
Yes, as a member, and for that particular time, I was a member of the task team. Although I will quality assure, because of my virtue being at the provincial investigations unit or directorate, we had all provincial staff were submitted to us, and we had to look at them before they were transmitted to the PP.
Yes. Now let's just go to the issue of Mr. Maimane's involvement. You accept that Mr. Maimane was part of, let's call it the pressure that was being put. There was a lot of pressure around this particular report, correct?
Yes, and Mr. Maimane being a leader of the DA and the complaint itself being emanating from the DA MPL in the Free State.
Yes. And you accept that there was a lot of public pressure for the report to be released?
Even the time that it took for the investigation, it was also putting pressure on the office to release the report.
Yes, because it was now like 4 or 5 years since the thing started, correct?
Yes.
Yeah. And part of that pressure is what the public protector then transmitted to the team to say, let's prioritize this thing. Let's make sure that it happens on time. And that's why you sometimes had to work until late, as you correctly pointed out. Am I right?
Yes, like I said in my previous answer, it seems as everybody was involved under this matter was under pressure. Mm-hmm. And that will apply to everyone, whether it's the PP or it's us as investigators. Everyone was under pressure to finalize the investigation.
Yes. And indeed, it was then finalized in February, as you correctly point out.
The 8th of February.
Yes. Then you accept that the what they call, when you say the complaint in the report, you are basically referring to the 3 complaints that came from Mr. Jenkinson rolled into one, correct?
Yeah, if in any investigation, if I say I'm referring to a complaint, it's what the layperson literally tell the public protector.
No, you don't understand what I'm saying. Yeah, in most investigations, you will have one complaint, correct?
Yes.
I'm saying in this particular, in this particular investigation, in this investigation, there were staggered complaints that came on different dates. I think the last one was May 2016. So that's what I mean. When you were saying the complaint, you meant those complaints rolled into one, because most of them were saying the same thing, correct?
Yes, it's basically, they were not made in one day. So we just combined them as it is to make them one complaint, because it was coming from the same person talking about the same subject matter.
Thank you. And that, again, that accords with the version of the public protector, because she was accused of not having looked at this complaint or that one one of the 3. But her answer was that most of those complaints were addressing the same thing. That's why the team and her regarded them as one thing and assessed them as such. You obviously agree with that.
Yes, hence, if you go to the page, to the beginning of the report, it will summarize the complaints and then put them as they are.
Yeah. Because anyway, that's fine. So then there was this report and this point that we just spoke about now, which is that there was then a call by Parliament to investigate specific issues which had not been raised in the previous complaints, correct?
Yes, it appears there was a call by by Parliament that the investigation that was carried on, it does not cover all the aspects because it does exclude the role played by politicians in the implementation of the project.
Yes, but that's the point I'm making. In the original complaints, there was no specific issue that dealt with politicians, correct? But now there was a specific...
there was no specific issue as it may, to say a particular politician did, the particular politician did what?
Yes.
But the main thing, the main complaint was about the project and what happened.
Yes.
And it doesn't, there is no reference. Okay, no, you can come in.
No, you go.
Okay, no, I can confirm there was no specific complaints which says Mr. So-and-so did what. Okay. It was a complaint related to the project.
Yes. And in fact, what happened is once it was announced that there was now a new focus on politicians, the DA itself then weighed in and sent a letter in support of its allegations against politicians, correct?
Yes, I don't recall the letter, but if the letter came in, then it should have been there.
Yeah, no, but it's referred to in the report. Or I suppose when the report was issued of the second investigation, were you still at the public protector?
Yeah, no, when the report was issued, the first one, the one that is under the discussion now, which is the Friday part one, I was at the public protector. But when the second one was issued, I was long, I think it was somewhere in 2019 or 2020. Yes. But I just read the highlights of it somewhere.
Yes. Okay. Well, but you should be aware of this because it was part of what informed that investigation, which you say you were the investigator of, and which you had incorrectly said was...
It was focusing on.
Yes. Okay. Anyway, let me take you to Bundle H, item 20.
Okay. Can I ask that? Can I ask if it can be displayed?
Yes, I'm sure that
they are trying to do that. Advocate Mpofu, you said bundle 20. Bundle H.
Bundle H, item 20, Chairperson.
Item 20.
Yeah, you just give us a moment. Okay. Filter through us on the Parliament network, but we just give us a moment. We're going to sort it out.
Just a few minutes, seconds.
Okay.
We'll get there. Come, Tsepo. Is that what you're looking for, Advocate Mpofu?
Yes. You see that, Mr. Rajani?
Yes, and if with the date of the letter, I was certainly within the employ of the PPSA.
Yes, correct. That's what I was trying to show. Yeah, you were still there. All right, can you just roll it down a bit? Yeah. So I'm reading this just to support what I've just said, and you don't have to worry much about the content. I'm coming to the point that this would have been the first time that there were specific allegations against politicians. So this is the original complainant, and he says, I've noted as the original complainant in the previous report on your investigation into the Free Day project that you have initiated another investigation into the role of politicians in this project. I hope you share the view with me that political architects of these projects cannot be allowed to avoid accountability after criminal charges have been instituted against the Department of Agriculture officials and various companies and other individuals. You've already confirmed that. We all know that he was suspended and criminally charged flowing from the reports of the Treasury and your report of 2018, correct?
Yes.
That's Mr. Tabete, the HOD, yeah. Then he says, there are at least 3 main political role players in this project, namely former Free State Premier, Mr. Ace Magashule, and former Agriculture MECs, Ms. Mamiki Kabate and Mr. Musebenzi Zwane. And then he goes on, Mr. Magashule has admitted that he and Mr. Zwane traveled abroad and so on and so on. The only point I want to make, I'm not cross-examining you on the contents, is that because this was a new focus, the original complainant himself felt that he should present this perspective of the involvement of the politicians, because he was doing so for the first time, correct?
Yeah, that's correct.
Yeah. Now, and then the second issue, because I don't want to mislead you, the second issue, which was the issue of the beneficiaries, you will agree with me that that issue, we can say it was a crossover issue because it was raised even in the first cluster of complaints, but it was also part of the second investigation. Am I correct?
The beneficiaries.
Yes, in other words, the beneficiaries issue was not a new issue like the politicians issue, because it had actually been raised in the previous complaints, correct?
Yeah, that's correct. But we should bear in mind that in terms of the Public Protector Act, it doesn't specify, it talks about once you, even if the complaint can specifically not mention anyone, there is that a provision for own initiative investigations that is always there within the framework of the PP Act.
Yeah, I know. Okay, that's wrong what you're saying, but we won't go there. You are conflating two concepts. The first one is no, you are. Let me explain.
I'm admitting to what you are saying, and especially with the view that when the first complaint came to the office, it didn't mention anyone. So what I'm saying, we should just bear in mind that the complaint itself does not limit a person, the investigator, to pursue any other avenue, even if they are not raised in the initial complaint.
Yes, no, that is true.
With what you're saying.
No, I know. I disagree with the reason you are giving. Yeah, I'm saying that is true. I've been putting that to many witnesses myself, but the reason for that is not the own initiative section. The reason for that is because the public protector has got wide powers. So even if there's a complaint from someone, she still is not limited by the complaint because a complaint by its nature takes you to places that you might not have even imagined when you start the investigation. So yes, we are in agreement. I think we only differ as to the motivation of that. So fine, let's move on.
And that is within the spirit of the Male and Guardian case as decided by the SCA.
Absolutely, thank you. And that's I see you've been watching the commission, this committee proceedings here. Thank you.
No, I used to work specifically with that with the invest. So the mail and guardian case is on my head. I have done it for over 10 years.
Oh, very good. In that case, then you can assist the commission with what is the main thrust of the mail and guardian case, which is the difference between an investigation, which is what you and I have just described now, as opposed to an adjudicative process. You understand that difference? I'm not going to ask you to explain it, but do you understand it?
No, I understand. The investigation of the Ombudsman Office, it's not adversarial. It's just inquisitive in nature. That's the system.
No, okay, it's not inquisitive, it's inquisitorial, but that's fine.
Inquisitorial, sorry.
Yes, yeah, no, that's fine. But it was not that aspect that I was exploring. It's the fact that an investigation, as you correctly say, is not limited because it can lead you to all sorts of other issues, unlike an adjudicative process, which you are now involved in as an advocate, which is confined to pleadings, and you deal with that issue. If it's outside of the pleadings, you can't deal with it, as opposed to an investigation, which can lead you to all sorts of other investigations.
No, that's
within that investigation.
That's correct.
Yeah, I agree, yes. And the example I gave, I don't know if you had been there for some time. The example that I gave to one of the witnesses was the Zondo Commission. You'll remember that it started as a narrow investigation into the activities of the Guptas, and then it ended up being the Zondo Commission, which went on for 4 years. And even in terms of the cost thereof, it was in the Public Protector's report called State Capture. It was because it was said that that investigation was going to cost 131 million, and which she did not have. But it ended up reportedly at about 2 billion rand, because it grows as an investigation by its nature can grow, correct?
Yeah, no, it does. And that's what the mail and guardian case tells us, that you shouldn't stop. You should actually pursue, go beyond
the four corners of the complaint. All right. Now that's very good. Now, you also said that, I think at many points in your evidence, when certain things were removed, you did not know why and by whom they were removed, correct?
Yes, if it was removed, if it was, yes, in terms of the issues that were removed earlier to the report being given to us, but for some of the things where if I was involved in removing that, I will be able to know why that was removed.
Yes, no, that's fine. That's fine. And you've also confirmed that Miss Linda Mulelekwa was also part of the chasing you as a team up. Sorry, yes. Because of the pressure.
The office of the chief of staff, it should be involved, and especially when the public protector is involved herself.
Yes.
Yes, it should be. That's why Linda, when the public protector wants to convey a message, she will have to do it through the office of the chief of staff. So I will agree with that one, that she was also part of the people who were putting pressure.
Yes. Now, Mr. Sitole was part of your team, correct?
Yes, he was part of the task team.
Yes. And so most of what you observed would have also been observed by him. You were almost...
Yeah, we were all actively, but specifically what I've observed should have been observed by Mr. Kekal. And because Mr. Sithole was there and he was assisting as well, but he was working hand in hand with Mr. Kekana most of the time.
Yeah. And both Mr. Sithole and you would then be aware of the same issues that were outstanding at the point at which you gave the report that was January 2018.
Yes, I think
You said that
all of us were aware, and I think it's something that we discussed, and it was common cause that those were outstanding issues.
yes, and those issues were the recent submissions from the Premier's office, the legal opinion about the PPP, evaluating the evidence in respect of the project's intended beneficiaries, and awaiting for further evidence from Mr. Maimane.
Yes,
Mainly.
those are the four things which we highlighted in January 2018.
Yes, and then you say that you were then, after that, that's when you were asked, or rather not asked, yes, you were asked by Mr. Ndo to work very hard in order to resolve those issues, correct?
Yes, Mr. Ndo gave us this thing in December. They gave us the task in December. And he then came back earlier in February after we have submitted the memo to say that the PP want to sign the report. So that's when we were all under pressure. We had to make sure that the report goes through to the
Yes.
PP.
In other words, to attend to those outstanding issues.
Outstanding issues we had to, at that particular time when we raised them, we were also, I think we should have simultaneously been attending to it as well by sending correspondence to various people who we could get assistance from in order to resolve those issues.
Yes, Advocate Radani, I don't know what's so difficult about this. I'm saying your version is that there were these issues and then you were put under tremendous pressure and you had to even work hard, at night. I'm saying that obviously must have been to attend to the outstanding issues. You may not have attended to all of them, but that was the reason why you had to work overnight between the 5th of August, or rather of February and the 8th of February, correct?
But not necessarily so for us to attend to the outstanding issues. At some point, it was not within our powers to obtain certain information. But some of the things maybe we could have looked at, that maybe the Gupta leaks, if we referred to it, because the emails were all over. But we couldn't get the statement from Mr. Maimane unless if we had traveled to the community to take the statement ourselves. And some other outstanding issues. The comment, the legal opinion was only, we were wholly dependent on NEMASIS. So yes. Part of us, which we should also, part of us working, was trying to finalize the matter, should be also be pressurizing those people to give us the outstanding information.
No, yes, no, we're together, Mr. Redan. I'm saying then, but at some stage, the report had to be issued. So irrespective of the fact that you might have attended to some of those issues, but some might not have been attended to. For example, Mr. Maimane had failed to deliver on his promise, but you couldn't wait for that. But on the other issues that you could attend to, you did attend to them, correct?
Yes, some of the issues that we could attend to, we did attend to them.
Right. Now, you've spoken about the meeting that was then had with the former premier of the Free State, correct?
Yes.
At which you were present.
Yes, I was present in the meeting.
And various issues were discussed in that meeting, correct?
Yes, in the meeting, the issues that were discussed was relating to this free dairy, the dairy farm.
Yes. And Mr. Mahashula explained why the provisional findings or the findings against him could not be sustained, correct?
I wouldn't say he explained, but what he did, actually, I think he also came with that letter that was sent to the 7-9 as a response to 7-9.
Good. Okay, that's true. So he brought with him that what you call the very detailed response to the Section 7-9 notice, correct?
Yes.
And in his responses, he would cross-refer to it at times, correct?
Yes.
And therefore, it should not be surprising that the meeting didn't last for that long because it was a follow-up meeting, correct? And already he had given a detailed response according to you, correct?
Yes, there was a letter about his involvement. And the only thing that was, we can call, that was the first time that maybe he had to explain himself in person rather than in that letter that he wrote earlier on.
Yes, no, I accept that, Mr. Redan. I'm simply saying it was not like your normal meeting where you go and have an interview with someone cold for the first time. He had already given a detailed response. He even brought it with him, and that obviously contributed to the meeting being relatively shorter than a normal meeting. If you were to start afresh and go through all those issues in his detailed letter, you would have taken longer, correct?
Yes, and because I was not the one chairing the meeting, so probably I think the public protector had that in mind when she was chairing the meeting.
Thank you. Yes, no, that's fine. And then you say in your statement that the public protector said she wanted to have a constructive discussion with the SG. Well, that happened while you were still in the meeting.
Yes, she mentioned that, and she informed us that we are excused. Then we left the meeting and we left them alone, the two of them alone in the boardroom.
And you were doing the recording, correct?
Yes, I should. I would presume there was no way that I would go to a meeting without the recording.
Why are you presuming now? You were doing the recording, correct?
I was doing the recording.
Yes, thank you. And so after that, after she said that, you stopped recording and you left, correct?
Yes, I left with my recorder.
Yes. So if we get the recording of that meeting, there'll be a part which says, okay, I now want to have a constructive discussion with the SG, correct?
Yes, if the recording was not stopped prior to that statement being made.
No, but you've just said you will stop the recording after the statement was made. So which is which?
No, I'm saying it will be clear if we go back to the recording. When the meeting adjourns, that's when we normally stop the recording. But if somebody is still saying something relevant to the meeting, then then that information should be there in the record.
Advocate Redan, please assist us. Please. I'm asking you a very simple question. You said that you stopped the recording after the statement was made. It's either you stick with that or you change it, or as you put it, it depends.
The reason why I really don't, the fact of the matter is I'm not in possession of the recording. The public protector office might be in possession of that particular recording in their devices. So
Okay.
that's why that's. But if that recording can be played, those statements can be heard according to the to what.
All right. Okay. Well, let me assist you with, that the public protector denies having made that statement which you attribute to her in quotes. She accepts that she stayed behind and had what one might call a courtesy meeting with the former premier, but they were no longer discussing the issues to do with the investigation. You obviously can't dispute that, correct?
Yeah, because I presumed that the fact that she excused us from the meeting, whatever that she discussed after, it was not relevant to the investigation.
Yes. No, your presumption was correct, except that you want to mislead the committee into believing that it had something to do with your investigation. Correct?
No, I disagree with you. I never intended that the meeting between the SG and the PP had anything to do with the investigation. The context of my evidence is that whatever that was related to the investigation was concluded.
Okay.
When she excused us from the meeting.
Okay, no, that's completely acceptable. But I'm saying that you are giving false evidence now, because the impression you wanted to give initially was that this was something to do with the investigation and that it should actually have been recorded. But now you are changing your evidence.
But I'm the one who drafted I'm the one who deposed to the affidavit. And I'm telling you correct version of the event. I have never intended to say that the meeting between the public protector and the SG was to discuss the investigation. The part of the investigation was completed when she excused us from the meeting.
Yes, that's the part where I'm saying you are giving false evidence, because you are quite right. If it had nothing to do with the investigation, then there would have been no need for it to be recorded, correct?
Yes, there's no need for that meeting to be recorded.
And therefore, if someone says that meeting should have been recorded, they are giving the impression that it was part of the investigation, correct?
I never gave an impression that the meeting should be recorded between the SG and the PP, because I don't know what were they discussing in that particular meeting.
Okay, thanks. Can you go to paragraph 75 of your affidavit?
Yes, 75.
Yes, can you read it out?
75, Mr. Ndo and I left Mr. Makashula and the PP alone. I do not know what they discussed. I was not subsequently informed, even though I was the lead investigator on the case. The meeting should have been recorded as it was related to an investigation. However, it was not provided. I was not provided with the recording for the purpose of compiling the report.
So
again, I will repeat this, Advocate Mpofu.
Yeah.
My impression of the meeting that was supposed to be recorded, it was the meeting wherein me and Mr. Mtupi were sat in, which was for the purpose of the investigation, which that meeting was recorded. And I'm not privy to the discussion between the PP and the SG. And if they had discussion, it was something else. It was not about the investigation in as far as I understand.
Yes, no, I agree with you, Mr. Advocate Redan. But I'm just saying you're giving false evidence either now, what you've just said, or in your affidavit. So you must choose which one is true, which one is false. They can both be correct. It's either, as you are saying now to the committee, the meeting was concluded, and therefore there would have been no need to record the meeting because it was about something else. Let's call that A. Or B, which is what is in your statement. Sorry, let me finish. Or B, which is in your statement that the meeting should have been recorded. The two things are irreconcilable. You just have to choose whether is it A or B.
When looking at paragraph 75 as it is, I started to say I do not know what the PP and the PP and the SG discussed.
Yes.
The only thing which I want to make it clear, you see, starting from the meeting should have been recorded as it was an investigation. It related to an investigation. With that specifically, that statement shouldn't have been there.
Okay.
Because I don't know what the two individuals, being the PP and the SG, were discussing.
Okay.
And
sorry, carry on.
And what should go on is that the only part which was supposed to be recorded or to be recorded was the part which related to the investigation.
And it was.
And it was recorded.
Yes. Okay. Now that's the problem I have, which I've had with your evidence from the beginning. Who drafted this statement, this affidavit?
The affidavit has been drafted by the evidence leaders, and I was given an opportunity to have a look at it, and before I even sign it, depose to it.
And when it was drafted for you, and then you signed it, you were happy that it contained what you said at paragraph 2 is true and correct.
Yes.
And you would agree that this is probably, I don't know how many times now, where we have found something that's not true, directly not true, or where the impression given is such that you need to change it or amend it.
I really wouldn't want to dwell much in the impression, but I'm just being honest with you, giving evidence the way I'm giving. I'm saying it was not important for the meeting between the PP and the SG to be recorded, because the meeting has ended when the PP excused us.
Okay, let me just break it down to you. So therefore, you are disowning or recanting or withdrawing that statement that says that the meeting should have been recorded.
That statement, I'm not sure if it relates to the meeting between the PP and the SG, that statement is incorrect. But if it relates to the overall meeting, why we called the meeting, it's correct.
No, it does not relate to that. So let's forget about it being correct here. It relates to the meeting between the, it says the first sentence, Mr. Mahashule and the PP alone. You understand that?
Yes.
So it relates to that part. And so are you therefore withdrawing the part that says the meeting should have been recorded?
Yes, the meeting between Mr. Mahashule and the PP has nothing to do with the investigation, unless if they discussed it, I don't know.
Yeah, no, okay, now, no, I know, I'm telling you, they did not discuss anything to do with the investigation. That's how we started. I told you that that's what the public protector is going to say. You have no reason to dispute that, correct?
No, I have no reason to dispute what they discussed.
Yeah. Okay, let me explain something to you, Mr. Advocate Radan. It's not so much about recording or not recording or that. What I'm busy portraying is that your evidence is not worth the paper it is written on. Because remember, this is a committee that's looking into the conduct of the public protector, correct?
Yes, but be that as it may, if I can answer that, the evidence that I gave, it is correct that the PP and the SG had actually had a meeting after the initial investigation meeting.
Yes, I agree.
I never intended to mislead anyone. What I'm saying is that I was excused from the meeting, then they had their own meeting. What was discussed there, I was not privy to it. And I think that is clear coming out of my evidence. The only thing that it's coming, you might not, you are looking at this statement that the meeting should have been recorded. And that statement, I don't agree with it.
Yes.
Because not every meeting should be recorded.
Yes. No, that's fine. I'm just saying, Advocate Radani, the problem with that, and you know, and I know, that that is the purpose of cross-examination. If, as it was required that the public protector should have been unrepresented in these proceedings, if Parliament had its way, but fortunately the Constitutional Court had its way. If that was so, then it might not have been possible to show that this information is untrue. And as I say, the point of that is not so much to show that your information is untrue. It is because the committee would then have been left with the impression that you or whoever drafted the statement were trying to create. That's the important issue, Advocate. And that impression, no, please hear me out.
Yes.
If somebody is reading this statement of yours, it is clearly intended to portray the public protector in a particular light. That, and it's the same light that a certain Mr. Samuel, who's also at least a self-confessed liar in his case, who was saying that there were some funny and business discussed privately between. Yes.
Just suppose Advocate Mpofu, Honorable Sukas.
Yeah, Chair, I object to the characterization of Mr. Samuel, and I think we have, in my opinion, we've had Mr. Samuel here, and that particular cross-examination was not very courteous at all. So to say again that Mr. Samuel is a liar is wrong.
Okay.
Just to add to that, the directives actually obligates us not to demean the personal dignity of the witnesses that appear before the committee. Just a reminder, Chair. Thank you.
Okay.
Honorable Sukas, Advocate Mpofu.
Yes, no, thank you. I think yes, I've heard the members from the ACTP and the ANC, and I want to rephrase. Mr. Samuel, who's a self-confessed criminal, said that the public protector and the premier had some shady meetings between the two of them. You understand that, Mr. Advocate Raidan? Do you understand what I'm saying?
Yes, I had I read somewhere in his affidavit about the meeting that happened in Bloemfontein.
Yes, no, I'm sure you even watched him as well, but that's fine. That's not the point I'm making now. I'm saying to you, left to your own devices between yourself and Mr. Samuel, the self-confessed criminal, anybody would be left with the impression that the public protector, and that's the impression that you wanted to create, had some shady meeting, and because she, according to Mr. Samuel, was pushing certain political agendas, or she was in the pocket of certain politicians. I can't remember the exact wording of how he put it. That's the real issue. The real issue is to portray the public protector in a particular light so that she can be removed from her job. That's what I'm concerned about. I'm not concerned about you giving false evidence and all that, but it is the intention.
I disagree with you when it comes to, I think, in my opinion, the purpose, the mere fact that after we have submitted our sworn-in affidavit, we are even called to testify. It is for these reasons that the committee does not only draw conclusion based on the documents that they see without having heard the witness viva voce.
Yes.
So I think the purpose of me explaining why I recalled that meeting where the PP, it's simply to put light to whatever that is written, and also to correct if there's something that is written, to correct it and explain it better so that the committee can have a view, an informed view, rather than just reading the affidavit only.
Okay, I don't think I'm getting through to you. I'm saying, sir, that there is a person here, a woman, whose career is on the line. There's an inquiry by Parliament, okay? And that is based on all sorts of impressions which are created by persons who hate her, or persons who want to see her losing her job. And I'm simply saying to you that the purpose of whoever put those false words there, whether it's you or whoever drafted it, or you and that person because you say you read it and you agreed with it, can only be to ensure that she loses her job. And that is wrong. It's unconscionable, and it's not something that you should do as a morally upstanding citizen. Would you agree with that?
That's why I'm saying I don't really want to comment on what you have said, especially when it comes to the purpose of the inquiry or us being called here. But the main issue that I want I wanted to go through, I believe that the purpose of me coming to give evidence, it's somewhere, somehow connected, and it has something to do with, if there's an error like this, I can be able to explain it, to say this is not what I meant when this was recorded down. If this was a motion court, your argument would have been a different one, or obviously then I should have made a supplementary affidavit to correct this version like I did. So basically what I'm saying, what is coming through is that oral evidence can essentially try to give, going forward, elucidate what has not been clear in the papers.
Yes, but yours is not discovered by oral evidence. Oral evidence is what you gave earlier when you were being asked questions by Advocate Bauer. That was also oral evidence. Yours has been discovered by cross-examination. So that it's not as if you came here and you said, no, you remember, if you go to paragraph 74.
But it's just to clear that I don't recall earlier earlier saying something like this, that the meeting between the PP and in when I was being led before lunch, I don't recall saying that that meeting should have been recorded. It's only coming out now under cross-examination that there's something like this which is written, and I'm explaining it, that be that as it may, that was not what I was saying. What I was saying is that the meeting between the PP and the SG was not supposed to be recorded because it has nothing to do with the business of the office, in as far as I understand.
Okay. Do you recall saying it on the 26th of July 2022 and swearing to God that you are telling the truth?
On the 26th of July, let me just double check whether it's the date that I deposed this affidavit.
It is.
Yes, I'm saying this is not a court of law. We are sitting with, this is not a court of law where we can say it's a motion. It's a motion papers where there are no witnesses who are being called. I'm saying, according to my understanding, the purpose of us being called here, after we have submitted affidavit to come and give evidence, is to give a perspective or to give the committee the true light, what is actually true, rather than what they read from the papers. So hence now you're asking a question. I'm explaining to the committee that no, the second meeting of the PP was not supposed to be recorded.
Yes.
Because it has nothing to do with investigation.
Okay. Do you remember Ms. Ibrahim, the person who spoke to you first when we started here?
Yes, I know Ms. Ibrahim.
Do you remember what she said might happen to you if your evidence is not true?
Yes, I do.
Okay. Now, I'm giving you the last chance. I'm giving you the last chance, Mr. Rodan. And this is very, very serious, please. Okay? I'm saying to you, you might not know this, so I'm just giving you information. Until we had to go to the Constitutional Court, the Parliament of this country was adamant that the public protector should not have legal representation where cross-examination is allowed. You understand that?
Yes, I understand.
Yes. And they lost that battle in the High Court in the Western Cape. And Parliament appealed to the Constitutional Court, and they lost again, thank God. But I'm saying, had that not happened, we would have been in a situation where your evidence might have been taken at face value and be responsible for the impeachment of the public protector, which you are trying to pursue for your own reasons, even by peddling lies to this committee. What do you have to say to that?
Again, I'm saying the version that I want to put, that I'm putting before Parliament, now that I'm explaining what's written in paragraph 74, 75, I'm saying Parliament should not, this committee should not go with a view that the meeting between the public protector and the SG was supposed to be recorded. I'm saying the correct view is that the meeting between the public protector and the SG was not supposed to be recorded, was not supposed to be recorded. And hence, I'm saying by coming here and also by now answering questions under cross-examination, it is for these purpose that I'm trying to, if there is misunderstanding in what is written down, then we can actually I can give a full explanation to the committee so that they don't go with wrong view.
All right. No, that's fine. I think I think the point is made, Advocate Redani. All I want to say is I think you have just demonstrated why it's important to have that the public protector had to fight for the right to be represented and to have cross-examination, even though the noisemakers and chattering classes out there feel that the cross-examination should not take place. It will, because as I'm sure you know, Wigmore, who is an authority on the subject, says cross-examination is the best engine ever invented by mankind to distill the truth. And as I always have my addition to say it also to distill lies. And I think that's what has just happened now. Would you agree?
In as far as you are referring to cross-examination, I don't know with what you when you say with what have happened now, what do you mean? Because I'm explaining myself to you that this statement as it is incorrect if we take it as it is. But what is correct, I'm telling you what is the correct version of the event to say this is what should have happened. Calling it lies is something else.
That's fine. Yeah, no, I think I'll take you out of your misery because I actually sympathize with you. But it's not right what you are doing, you and the others. If you have gripes with a person, if you have all sorts of issues, personal issues, you know, we all do, but it should never be taken to these levels where you are prepared to sell your soul in order to make sure that that person suffers. Thank you, Chairperson. I think I'm done with this witness. Thank you.
Thank you, Advocate Mpofu. We'll take a 15-minute tea break and come back with members' interaction. Thank you. I didn't say raise hands now, please.
Recording stopped.
Hey, it was excellent.
members session to interact with Mr. Ndijeni Raidani. They've raised their hands even before I asked for them to raise their hands, but that's fine. I'll start with the Honorable Mailam, followed by Honorable Sukas, Honorable Mulder, Honorable Mananiso, Honorable Lothridge, Honorable Gondwe, Honorable Heron, Lagude, anybody else? Ngosi, Skosana. That's all on the virtual. Thank you, Ngola. In that order. Yes. Mautwe, Maneli. Thank you. 1741, I start with Honorable Mailam.
Thank you, Chairperson. Good afternoon, Advocate Raidani.
Good afternoon, sir.
Advocate, you say in paragraph 15 of your affidavit, and I quote, "Indeed, a number of persons either left or were forced to leave after Advocate Mkhwebane took over," end quote. With regard to being forced to leave, does that refer to disciplinary processes?
Yes, it refers to people who face disciplinary processes, and also some of people who just resigned out of their own will. And there are a number of people that went when immediately after she arrived, the CEO who was there at the particular time also resigned. And then there was the chief of staff who was there, Mr. Jamini. He also left. And then there was also the CFO who left immediately upon.
Thank you. In paragraph 16, you say, and I quote, "Those of us who had been investigators in the private office, including Advocate Matlawe, Mr. Kekana, Mr. Sitole, Ms. Safaku, and myself, were moved out." Now, my question is this: when all of those people were moved out, how many investigators were left in the private office?
Initially, the private office didn't have any investigators, but soon as towards the end of Advocate Madonsela and also when Advocate Malunga came in, Malunga appointed a senior investigator, and there was always a junior to that senior investigator. And then it was Mr. Matlawe, who will then be a quality assurance manager who will report to the public protector when it comes to those activities of quality assurance. So what actually means it's when we left, no one remained as a senior investigator or anything in the private office.
Thank you very much. You say in paragraph 20, and I quote, "The public protector at times arrived, in my view, with a particular outcome in mind and then sought to justify that outcome irrespective of the relevant evidence or arguments or other people's perspectives." Can you give us some examples of that behavior?
When I was testifying earlier on, I did mention that the public protector, like for example, in the current Friday report, you will see some of the issues that we raised were still outstanding. And hence the public protector was pushing for the report to be released. And also, regardless of whatever, I didn't initially agree with her in terms of some of the things that were removed in the report. So another investigation that I've seen in the we have differed. We have different opinion. It was, for example, there was a complaint against the DG of the Treasury that the DG, when he was employed, he didn't disclose that he has a criminal, a paid admission of fine, something like that. And in that investigation, we were of the view that it was not necessary, but you could see that she had her own view on that particular investigation. She has taken a particular view and she's insisting on it.
Okay. On the evening of the 8th of February 2018, when you worked late with the Public Protector to finalize the report, what quality assurance was done on the final document?
We were actually, like what was presented in my evidence in chief, what we did specifically was to change that specific remedial action for them to look exactly what it is in the final report. And if you see exactly, so there were various things that were inserted during that night. And some of the findings were rephrased to read different from what was initially in the draft that we submitted.
But there was no quality assurance done on that document after you guys had amended it.
Yeah, there was no quality assurance, because quality assurance means somebody with an independent mind should then look at the document and check if it complies and all this other. So what we did was just finalization of the report.
Okay. In that final report, there's a comment that the inflated prices were difficult to determine. Now, that comment was a blatant untruth, was it not?
Yes, I will say, because earlier on the Free State Office managed to seek they sought services of somebody who did the comparison on the prices, and maybe we should have went with the version of the earlier report, which was that the prices were inflated.
Okay, so in the earlier versions, there had been sufficient evidence to support the finding that there were inflated prices.
There was, because the photos were there and some of the comparison that was done by a service provider that was engaged by the Free State Office. It was clear that those prices were inflated.
Okay. My last sort of area of attention is the meeting with Mr. Ace Makashule in October 2018. Who set up that meeting?
I initiated the meeting from an investigation point of view. And then the public protector approved, because she signed the draft subpoena to call Mr. Makashule to the office.
Okay. So would you agree that as the lead investigator and the person who set up the meeting, you should have been afforded an opportunity to properly question Mr. Makashule?
Yes, I agree.
Okay. Now, during the meeting, you were asked to leave the room while the public protector had a private meeting with Mr. Makashule. Had this happened in any other meetings that you were part of?
Well, not really. It was, for me, it happened the first time, because normally, unless if we have a stakeholder engagement, you might find that the public protector is having a one-on-one meeting with a particular politician, but the chief of staff, your spokesperson, will be present in that particular meeting. It doesn't. So it was the first time that the PP has requested a meeting with Mr. Makashula after and excuse us from the meeting.
Okay, but this meeting was not stakeholder engagement. This was an investigation meeting, correct?
Yes, the reason why Mr. Makashule came to the office, it was because it was an investigation meeting.
Okay.
But
Now, at the time-
later part,
That's going to be a last point.
Sure. Sorry, I interrupted you.
no, I was saying the later part of the private meeting between the two, it has nothing to do with the investigation.
Okay. At the time, Mr. Makashule was an implicated person, or at the very least, a person of interest in terms of the investigation. So my question is, should the public protector have had a private, unrecorded meeting with him in such circumstances?
I don't think it was necessary for the public protector to have a meeting with Mr. Makashule. And most importantly, Mr. Makashule was no longer a government, a public servant at that particular time. He was working full time for the political party, for his political party. So they might, for me, I don't see why they should have a secret meeting after the investigation meeting was adjourned.
Thank you, Chairperson.
Thank you, Honorable Mailam. I now proceed to Honorable Sukas.
Thank you, Chair. Good afternoon, Mr. Radani. My first question to you, given the seriousness of the allegations against the ex-premier, Mr. Ace Makashule, how long would you require to interview him face-to-face to perform a thorough and proper investigation?
Normally, we used to normally, I would say for us to have questioned him, it should have taken maybe 2 to 3 hours.
So the 30 minutes that you spend with him in that day, were you able to get all the necessary information that you needed for the investigation?
We couldn't get all the necessary information, rather than he kept on referring to his earlier response to the Section 79 notice, which was already in our possession.
You worked during the period of people like Mr. Samuel, who headed up the Free State office. Would you mind just telling us what was Mr. Samuel's reputation within the organization?
When I arrived, Mr. Samuel was a senior investigator. And when there was a vacancy in Limpopo, I heard that the public protector at the time, Advocate Mushana, approached him personally to go and apply for that post to head Limpopo province. So the reputation of Mr. Samuel was, he had a good reputation within the organization. He was a qualified attorney. He had a thorough understanding of the processes of the organization in as far as I can remember. And even the incident of him attacking or whatever that he had with the complainant, that incident was reported to the then public protector, which, because of the reputation of Mr. Samuel, she, instead of punishing Mr. Samuel, she eventually approved that there should be security officers in that office in Polokwane.
Thank you. At paragraph 60.3, you indicated that you did not agree with the amendments as affected by the public protector. Did you communicate this with the public protector, and what was the public protector's response?
Earlier on, during our meeting, remember this thing started as early during the day. We had to go, we were told we had to justify what is written on the report, but in any event, we were overruled. In that process, we was justifying why our report should be accepted as it is. That's when we gave reason, and we gave reasons why the report should go as it is. But as the person who has the final say, she then ultimately altered the report to look the way it is.
With regard to the issue of financial misconduct, I just want you to tell me if my understanding is correct. My understanding is that you are testifying that the findings that the prices that has been overcharged were removed, and that you believe that these details were important to understand the scale and the scope of the financial misconduct. Is that correct?
Yes, that's correct.
Could you tell me who removed that? Who removed the scale and scope of the financial misconduct, the detail of that?
It was most of the things that we removed were after the morning meeting that we had with the PP, and after when me and the PP were working, we were working during the night of the 8th of February 2018.
You received an Audi letter, and we've been hearing many people in the previous witnesses saying that they've received Audi letters for work not being completed on time, etc. At paragraph 13 in your affidavit, you state that work not being completed on time is performance and not misconduct related, and that disciplinary procedures were not being followed, or policies. Why was this distinction important, and what policies were not being followed?
The distinction is important because anything that relates to an employee's performance, it is not a misconduct. If you are saying somebody is not performing adequately, that is not a misconduct. And in terms of the HR policy, certain procedures need to be followed. Like you need to take that person to corrective counseling, to sit with that person and manage performance the way it is designed in the performance management policy, instead of charging that person with a misconduct in terms of the disciplinary code.
You conducted quality control on reports. I have a slightly different question to that. To the best of your knowledge, what quality control measures were in place to ensure S53 records were complete?
Come again, just repeat your question from the last part of it.
Okay. To the best of your knowledge, what quality control measures were in place to ensure S53 records were complete? And were you in the yes?
S53, are you referring to the Rule 53
yes.
Records?
Yeah.
The Rule 53 records, normally what happens, it's the person who is responsible for litigation should be, it's the person responsible for the compiling of the Rule 53 records, and that has to be done with the particular investigator who investigated the case, because it's the person who will ultimately give you the source documents which he relied on when he compiled his report.
Lastly, Mr. Radani, I just want to ask you, in your opinion, you've been a shop steward for many years. The public protector, the office of the public protector, would you describe it as an environment that was punitive in terms of either performance or mistakes made by staff?
The public protector, we are coming from the two previous public protectors with Advocate Mshuan and Advocate Matonsela, where people wouldn't just necessarily be charged for less offenses or for non-performance. Rather, correct procedures will be followed, and will be followed if somebody is not performing. And then there's a policy in place in terms of performance management, which was followed to the latter all through the years.
Thank you, Mr. Radani. Thank you.
Thank you, Honorable Sukas. I now recognize Honorable Mulder.
Thank you, Chairperson. Good evening, Advocate Raidani. I'm going to start off, and I'll try to be brief. I'm going to start off with continuing with the last point that was just made now by my colleague. During your testimony on a number of occasions, you indicated that there were certain things happening within the Office of the Public Protector, and it was alleged that the Public Protector may not be friendly towards this one or that one, or this was moved, or et cetera, et cetera. And you were confronted on numerous occasions to say, but do you have clear evidence that it was a Public Protector who instructed this or that? Would you say that there was a bit of a toxic working environment within the Office of the Public Protector in general at that time?
The environment was toxic because a number of people there were instructions wherein was issued by the public protector herself to charge certain individual when it comes to them not delivering. Certain people, there were instructions given to the CEO to go and charge particular individuals. So that made the whole working environment in the PPSA around 2017 and 2018, it was not conducive. Hence, it was informed by mass exodus of the people from that office. Anyone who could get opportunity outside was prepared to leave. And some who couldn't get opportunity, they were then dismissed after that.
Thank you. I've got one more issue that I want to deal with. Approximately the last 30 minutes of your cross-examination, we all received a lengthy exposition with regard to cross-examination and the virtue of cross-examination. And we referred to Wigmore. It comes from the case of Lilly versus Virginia in 1999. And I want to take you to paragraph 75 of your affidavit, because that was used to convince the committee that you are giving false evidence and that you should not be trusted or believed. As a matter of fact, at some stage, I think you were almost threatened with perjury because of your evidence. Now, if you look at paragraph 75, it says the following: Mr. Ndo and I left Mr. Magashula and the PP alone. And then you say, I do not know what they discussed, and that is what you gave evidence in oral evidence as well. I was not subsequently informed, even though I was the lead investigator on the case. And then the following sentence is being used to indicate that you gave false evidence and that you should not be believed. The meeting should have been recorded as it was related to an investigation. However, I was not provided with the recording for purposes of compiling the report. If we can take the sentence, the meeting should have been recorded, and we change the word as with the word if.
Yes.
If you read the sentence and it says the meeting should have been recorded if it was related to an investigation, because a huge argument was put forward now.
No, Chairperson.
Mr. Mpofu is still here.
Oh, this is ridiculous. I'm still here. Yes.
Sorry. Just pause, Honorable Mulder. Advocate Mpofu, you are
Chairperson. Sorry.
Wait.
Yes, I did raise my hand.
You've raised your hand, and the member is on the platform. I'm not going to disrupt him until he finishes his question. And now you're coming in before I even acknowledge you, because I've seen your hand.
Apologies, Chair. No, the hand has been up, and I thought you were not ignoring it.
No, I'm not ignoring any hands here, and you know that I acknowledge any hands that I see. I don't interrupt somebody on the platform until he finishes. I do that to you as well. Please hold back.
I have the right to object at any stage, but it's fine. Let him finish.
Thank you. Please continue.
Yes, thank you, Chairperson. I was told earlier that a jazz symphony should be listened to the end, because it's supposed to be beautiful. I'm continuing with paragraph 7.
Not this kind of music or music.
Yes, the wonder of cross-examination. Chairperson, no, I'm back with 75. I want to ask you, Advocate Raidani, you clearly say that you were not privy to what was discussed. Would you agree that if the public protector discussed the Vrede case with Mr. Magashule alone behind closed doors, technically that should also have been recorded?
Yes, that's correct. I agree with that.
Would you also agree that it is possible that they discussed the Vrede case in the absence of anybody else?
Honestly,
Yeah, it's possible because they would, and it's possible that they might have discussed the Vrede
It's
case.
possible because nobody knows what was discussed behind those closed doors and it was not recorded.
Yes,
I want to
that's
ask you a last question. Would you agree that in terms of perceptions, it is not an ideal situation that the public protector meets behind a closed door with the main politician being investigated in this case?
Yes, I agree.
I've got no more questions. Thank you.
Thank you, Honorable Melder. Before I go to the next Honorable Member Mananiso, Advocate Mpofu, I recognize your hand.
yes, thank you, Chairperson. No, I wanted to ask you to stop this, what Honorable Mulder is doing, where he even goes as far as trying to edit the affidavit that the witness has confessed is wrong and does not express what he was saying. That's really, Chairperson, this is an abuse of the system. And it moves now from the sublime to the ridiculous, because we cannot allow a situation where this opportunity for members to ask questions, which is an important part of the process, is allowed to be abused to try and repair the irreparable. Number two, on top of that, I have protested here that I'm not given the right to ask questions arising from the members' questions, and which is totally unheard of and unfair. But you've made your ruling about it. You only give that opportunity to the evidence leaders. And that is why this opportunity is then open to such abuse by the Mr. Mulders of this world. If people have come here to try and push a particular agenda and with preconceived ideas, that's fine, that's their privilege, or predetermined outcomes. We've seen it in the past 3 weeks that the questions only go to a particular direction, with the notable exception of Honorable Heron, who's very exemplary, and other people. But that's fine, the people are free to do that, but really let's not push it to levels that are just laughable in front of the public, because it means we're undermining the intelligence of our people. Because I could say that, I mean, is it possible that Honorable Mulder is a racist? And then someone says, yes, it is. And then what? What kind of question is that? How can you say to a witness, is it possible that they discuss this? Possible based on what? Anything is possible. Is it possible that pigs can fly? Yes. But really, let's not undermine the intelligence of South Africans. Our people have paid a lot of money for this process. No, Chairperson, I want to say the last point, which is that
you've made a point. I don't want you to make a statement. You've made your point.
Okay.
It's clear the point you're making.
Fair enough.
And I
object in the strongest possible terms. It must not be allowed. It's wrong, and it's unfair, and it's unparliamentary, and it is not in line with the oath of office that everyone has taken before God here to
thank you,
to make sure that they follow their conscience.
Thank you, Advocate.
You cannot follow your conscience by being so biased.
I want you to stop, Advocate Mpofu.
Thank you, Chairperson. I'm finished. I'm finished here.
Thank you. Just hold back, Honorable Melder. I'm going to attend to this issue. I think it's important that the point is made here and very clear. The last thing that you're going to do, Advocate Mpofu, is to tell members how to ask the questions. That's the last thing you're going to do in the members' session, interacting with the witness. as a chair of this inquiry, I'm never at any point going to allow that, because they don't do that to you as to how you need to cross-examine a witness. That's
No,
the
they
first
do,
point I want to make.
They do, and you allow it.
Dialogue. I'm not having a dialogue.
No, but you can't misrepresent the facts. You have allowed people to interrupt my cross-examination.
I'm not having a dialogue with you. Please, I'm now addressing this meeting. Thank you. And so the second point I want to make to you, all of you colleagues, and in response to this, and I'm hoping that you're going to refrain next time in terms of even attempting to patronize members here and begin to say this one is better than this one, I prefer this one, because that's not what we're going to allow here. Thirdly, and very important,
No, don't insult me, Chairperson, please.
I've not recognized you to speak. I hope you were not going to do that. I've
My
not
hand is
recognized
up.
you to speak.
Okay, my hand is up.
If your hand is up, you know how to put your hand up. You don't interject as I'm speaking as a chair. And the third point I want to make, which evidence leaders do, you do, every member will be in his or her own right to make any hypothesis here. Was Honorable Mulder did not change what the affidavit was saying. He made a hypothesis about that affidavit, and that's his way of questioning the witness. And so I would want, uncomfortable as the issues might be and the kind of questions, because from evidence leading to cross-examination to members interacting, we are not dealing with necessarily nice questions and issues. Some of these issues that are being raised are uncomfortable to all of us. And I implore you and all of us here that we've got to exercise that patience and tolerance of each other's views and the kind of difficult questions that are going to be thrown. When there are issues that are irrelevant, you know that you have all your right to raise your hand and indicate that, Chairperson, this issue is irrelevant to this motion in this way. And there's no reason why I should not respond to that as I do to all other members. So I really want to make those points before I proceed to the next honorable member, which is Honorable Mananiso.
No, Chairperson, you said you were going to recognize me. My hand is up. I want to respond.
I did not say I'm not recognizing you. Honorable Mananiso has not even spoken. I would like you to be patient, Advocate Mpofu.
Chair, I'm pleading with you. I'm pleading with you. Let me respond and then we move on.
I'm acknowledging you. You are going to speak. I don't want you to, you need to keep your cool as you have done always. Advocate Mpofu, I now recognize you.
Thank you, my Chairperson. Chair, I'm saying the following. I'm not saying it for the first time. Firstly, what you're saying is not true. Remember, the statement that that Honorable Mulder has just made about jazz and all that was made in the context of you allowing people to interject and to come in the middle of my cross-examination. That's how I made that statement. And you have allowed that. So it's not true to say that I might not object like other people object during my cross-examination. It's simply not true. It's not borne out by what has happened in this committee at least. So let's put that aside. The second issue is that I have a right to object to any unfair treatment of Advocate Mkhwebane as perceived by her or by me representing her. You have a right to rule that my objection is right or wrong. That's your privilege. But mine is to object, and I will not be intimidated from that responsibility. And all I'm saying now is that it's also not true to say that Honorable Mulder did not change the affidavit. He did. He changed. He said you must move the word as to and put if. If that's not changing, then my name is not Darlene Pof, because that is exactly what he was doing. And that, Chairperson, is not allowed. That is not me dictating as to how members should ask their questions. Members can ask their questions, and I have no particular discomfort with questions being asked, whether they are in our favor or against us. With that's fine. That's par for the course. I've done that for many decades, listening to questions like that. But the issue is that you may not allow a situation where there is a blatant unfairness, such as the one that you are allowing now. Number two, and this is my last point, you are quite right that I'm entitled to raise issues of irrelevance, and I have done so. But the problem with that, Chairperson, and yesterday you raised my voice at me because I was raising this point, and I was not raising it negatively. When I was saying you should get advice on some of these issues, because it's not your area. I'm a lawyer. I'm not a doctor. So if someone talks to me about medicine, I will humble myself and try and find out. And I was saying the following. You, Chairperson, you don't know what the meaning of irrelevance in terms of evidence is, because irrelevance is not the same irrelevance that's used in our everyday language. Legal terms, it's like saying there's an exception. There are legal terms, exception, embarrassment, and so on. They don't mean what they mean in normal language. So when I say something is irrelevant, I don't mean that the member is not entitled to ask it. I mean that it's not relevant to the question. And there are categories of relevance. There's opinion evidence, there's hearsay, there's all sorts of similar fact evidence, and so on. It is those categories. And the unfair thing is that you have the sole right in terms of the rules of this committee to determine relevance or irrelevance. Now, if relevance and irrelevance is going to be determined by someone who doesn't know what it is, then where are we going?
To express yourself. Thank you very much. Honorable Manani, so I recognize you.
Thank you.
Okay, thank you, Chairperson, and let me greet Advocate Raindani. My first question to him is, I just want to check with you if you have personal issues with Advocate Mkhwebane.
No, I think I made that clear earlier on. I don't have personal issues with Advocate Mkhwebane, and I'm neither bitter that I left that organization.
All right. And then my other question is with regards to your affidavit on paragraph 3. You indicate that you have not had access of your emails. So I want to check with you, how instrumental or relevant are those emails to this particular committee?
The emails are relevant because what transpired during the week of the 5th of February 2018, it was communications were done via email. But be that as it may, the evidence leaders have managed to access some of the emails, and they have shown them to me. I have seen them. So whatever the emails that were relevant, I think they have retrieved them, and then they were part of the evidence.
Okay, and then my other question is with regards to your affidavit from paragraph 12, 13 to 14, with regards to unpleasant environment. I just want to check with you, when did this particular environment started? Before Advocate Mkhwebane or when she came in?
Before Advocate Mkhwebane, people might have had issues with the incumbent then, but the issues that they had will not be similar to what experienced under Advocate Mkhwebane, because after the situation became unpleasant after her arrival, Like some things that you have read about the TV being changed from E-News to ANN7. Those things really did happen, although some of us, we don't view them as material issues. And people were being threatened on a daily basis. I've sat in meetings where PP instructed CEO to go and charge certain employees. So hence I'm saying environment was not conducive for one to be in, because you will not know whether today was your last day or whatever that you are doing the correct thing. At any time, people could be disciplined.
Okay, and this one of Audi letters, I think some of the members have asked it, Honorable Sukers, but from my side, I just want to ask you with from a point of being a shop steward, do you think this particular Audi letters had impact in terms of the performance of your colleagues?
Yes, the Audi letters that have been given to colleagues, basically it has affected them in terms of performance, because no one will sit comfortable not knowing what future holds for you. So basically, those people who have been given letters, some of them will come to us. And it is just unfortunate that a lot of people who were facing this were senior investigators and senior managers. So it will not be an ordinary member of the staff who is at the lower level.
Okay. And then my second last question is, how do you know the PP got a call from Zwanele Manyi of the ATM to console her? How did you know about this particular call?
I was in the boardroom when the call came in. When Zwanele Manyi even offered that it was just after the ABSA disaster. And he even offered that some of us investigators can go, the PP can come to ANN7 and some other things. But I didn't take cognizance much of that call. It was not important to me.
Okay, as a follow-up question, do you think the association of the PP and politicians has influence in terms of her work?
It is, because as the public protector, you're not supposed to be associated with politicians. Because I read somewhere where some of the people who were being investigated were also attending a 50th birthday party celebration. Or as a lawyer, for me, that's very concerning. If you're investigating people and invite them to your birthday party, it's something else.
Okay, and then my last question, Chairperson, is with regards to paragraph 45.1 on issues of a violation of section 217 of the Constitution. I know it's about preferential procurement and what needs to happen when once it's in supply chain, and as well the financial officer in authority. So do you think with what we have noted on your affidavit, the person who was in financial authority have failed to execute his responsibility, or do you see that particular person as a corrupt person? Thank you. That's my last question.
The person who was sitting there, the accounting officer, who is the head of department, he has failed to ensure that to take reasonable measures to ensure that these financial irregularities does not occur. And that is despite after being warned by the accountant general. And because something like 143 million was then transferred after the report of the accountant general. For me, it's that has been the relevant accounting official of the relevant accounting officer of the department was not acting in good faith. But when it comes to the issue relating to corruption, to say that, I don't think that would simply suggest that the person is corrupt. or that, because it might mean maybe it's just a simple dereliction of duties. Thank you.
Thank you. Honorable Lothrit.
Thank you, Chairperson. And well, it is good evening, Advocate Radani. Advocate Radani, I just want to go to paragraph 14 of your affidavit. It was quite a few questions asked about that during cross-examination, but I want to make sure that I understand it correctly. Where you say that part of the reason that I regarded the OPP as being an unpleasant working environment was my perception that I had become a target for the PP. So that was, you do not state it as a fact that it was the case, but it was in fact your perception, how you perceive the environment. Is that correct?
Yeah, that's correct.
Thank you. Then if we go to paragraph 25 in your affidavit, it's about the quality control and the fact that the think tank was not, well, it was dissolved basically. You state that it included the chief of staff, this new smaller committee who had no legal qualifications. It excluded the deputy public protector. It included the CEO as well as the public protector's spokesperson. Now, given the makeup of that particular smaller committee, how did you experience the kind of quality control that committee, consisting of a number of people with no legal qualifications, no experience in investigation, what was the quality of the quality assurance?
Obviously, once you have a number of people who sit, who are not qualified to sit at a particular committee, whatever that will be your output, it won't be something that is of quality. Because if the report goes to think tank, where there are legal managers only and there are legal brains only, it won't necessarily be the same when it goes to a committee where there are certain people who don't have legal backgrounds. So that will really affect the quality.
Thank you. And then I want to turn to the evening when the final version of the Freda report was signed, and you also in your affidavit describe a situation where you were with the public protector and you were typing and making amendments to the report, and then later on she was typing. Did the public protector during that process provide any reasons why she is in fact amending, deleting certain sections, etc.?
She didn't give reasons per se that because we never had that discussion about why is she amending this, but I would say some of the comments that came in earlier, maybe from Nemesis, might have found their way into the final document. But as for why PP was changing reasons, she didn't state why she was doing that. And maybe what I presume, it's some of the things that the statements that came into the report, I will presume that she had the first-hand information. Maybe she had had a discussion with those who were implicated. And that's why maybe she changed the findings the way she did.
Thank you. And then when we go to the meeting that you had with former Premier Ace Magashule, did you have any preparation beforehand in terms of the questions that you are going to ask, because you set up the meeting?
Yes, we usually do the questions that we want to ask, and we usually had to do that. Then at some point before the meeting, the memo and explaining everything should be sent to the PP, so that she can be in the same page with the investigation team.
And did the public protector ask any of those questions that you had sent through?
I think it happened a long time, but I presume due to the questions, I think she should have followed the format that we have drafted the questions going to the meeting.
Thank you. Then my last question, Chair. Now, the meeting was set up, as I understand it, to get more clarity and information regarding the Section 7.9 reply from Mr. Magashule. Now, if you can recall, and I know it is a long time ago, but you recalled that it was quite an extensive reply on the 7.9 letter. To your mind, was it sufficient to remove any adverse findings against Mr. Magashule?
Maybe just to correct this, the meeting with Mr. Magashule at a later stage was only called for the purposes of the second investigation, after Parliament has requested the public protector to look at the role of the politicians, because the initial the report that we are discussing now did not point any finger to the politician. So I'm not sure if you want to rephrase your question. Because the 7.9, there was no meeting about the 7.9. It's just that Mr. Magashule used the letter of the 7.9 to explain himself in the meeting.
Okay, I think that's where the connection came. But in your mind still, do you think there was sufficient information to actually not have an adverse finding? If you are referring to the Section 7.9, yes. Section 7.9 answer to which Mr. Magashule sent to the office, there was no sufficient information that justified the removal of certain findings. Thank you. Thank you, Chair.
Thank you, Honorable Lotrit. You will be followed by Honorable Gondwe.
Yeah, Leboga Chairperson. Waranden, how are you?
Well,
can you hear me?
Yeah,
I'm fine. All right. We heard evidence yesterday from Advocate Chualule that there was an exodus or redeployment of staff that were working in the private office prior to Advocate Mukhwabane assuming office. Would you agree that unlike a newly appointed minister, whose appointment is largely political in nature, there was really no need for Advocate Mukhwabane to redeploy the people that she found in the private office to other units within the organization, more so given that her appointment wasn't strictly speaking political in nature, and the appointment of those people in the private office was not tied to the appointment of Advocate Madonsela?
It's something that it didn't sit well with us as the union, because a number of each and every incumbent will come to the office with his or her own people, and those people get to be employed permanently. And when that particular incumbent leaves the organization, these people are left there, and then they end up being just without having proper jobs or anything. Then they end up, when the new one comes in, that person, you find out that he brings his own stuff. And that created a lot of problems, because we have had so many people that could not be placed, could not be utilized, who were on higher salaries. Like, for example, the secretary of the PP was on level 12. So you now sit with somebody who is on level 12, whom you can deploy anywhere in the organization.
Thank you. And I think the next question I'm going to ask, somebody has already made reference to paragraph 20 of your affidavit, where you state that at times the PP arrived with a particular outcome in mind, and then sought to justify that outcome irrespective of the relevant evidence or arguments advanced by others. Are you trying to tell us that Advocate Mkhwebane was biased, partial, and not open-minded in the manner that she dealt with investigations and reports that were before her office? And are you also trying to tell us that she would go to any length to ensure that she arrived at a particular outcome, even if it meant ignoring, disregarding evidence, or departing from the evidence, placed before her in the course of an investigation?
Okay, thank you, Honorable Gong. What I'm saying, and I want to point out to the committee, it's not me or my view that Advocate Mkhwebane has done so, but it's the view that has been expressed as well by the courts. In the matters like ABSA, the courts expressed the same view, and in the matters relating to the recent one of SARS and the President Ramaphosa, those things, the courts expressed that when they reviewed and set aside the reports submitted or completed by the public protector. So I share the very same sentiments as the courts.
But do you agree with what I'm saying, especially the latter part about her, going to any lengths to arrive at a particular outcome, even if it included ignoring, disregarding, or departing from the evidence?
Yes, and that's what I'm saying. The courts has found that, has expressed those views. So I wouldn't add much to what the court has said when it comes to various investigations that were reviewed.
All right, thank you. In paragraph 30 of your affidavit, you state that in your view, the public protector's managerial style was not conducive or beneficial to comprehensive investigations. Please expand on this. What about her managerial or leadership style was not conducive to comprehensive investigations? How would you describe her managerial or leadership style?
Firstly, the approach was that whatever that was implemented by Advocate Madonsela should be done away with. And then lately, I've heard that those investigation units that were created by Advocate Madonsela and then maybe Advocate Mshwana before has been done with. So just when looking at that, someone then comes into the organization, you then have your chief of staff who is not legally qualified, and then you move on to exclude executive manager and your own deputy. So that leaves, too much to be desired out of that action, because you can't completely exclude the deputy public protector who has been appointed by parliament to be your assistant, and then exclude executive managers when it comes to certain decisions. Hence, the ABSA report was a disaster.
Are you done?
Yes.
All right, thank you. We heard yesterday from Advocate Chiwalule that the think tank would ensure that reports are subjected to rigorous debate on, amongst other things, the facts, the law, the language, and the tone by senior managers and provincial representatives. And the Deputy Public Protector was part of this, the think tank. But then you now tell us that the think tank was replaced by a smaller... The think tank, yes. But you now indicated in your affidavit that the think tank was replaced by a smaller and more exclusive committee that excluded the Deputy Public Protector. Why do you think he was excluded from the smaller and more exclusive committee that replaced the think tank? And in your opinion, did the DPP have a good working relationship with Advocate Mkhwebane? Did she, for example, allow him to take the lead in relation to certain decisions pertaining to the organization?
Very loaded question. I hope you got it, Mr. Raidani.
Yeah, with the relationship between the DPP and the PP, I don't think it was one that is conducive, because the DPP was only delegated with training instead of investigation. And in as far as I can remember, their relationship was not that solid. The DPP was excluded in a lot of things, and he would just come to the office and sit there most of the time. And he was not before, when Professor Madonsela was still around, when they go to press conference, the DPP will also form part of that delegation, and even on the think tank, the DPP was part of the think tank. So, but after the arrival of Advocate Mkhwebane, the DPP was fully excluded from the investigations activities.
Thank you. Chair, this is my last question.
I remember.
Oh, carry on.
I wanted to make a reference to when in December of 2016, I had planned to go to the Eastern Cape to do file inspection with the DPP, but his trip could not be authorized by the PP then. Then I had to go with junior staff from his office.
Thank you. This is my last question. So in paragraph 74 of your affidavit, you indicate that the PP, yourself and Mr. Mutupi, you corrected that it wasn't Mr. Ndo, it was Mr. Mutupi, had an investigative meeting in October with Mr. Magashule. And during that meeting, you said the PP did most of the talking and you were unable to ask Mr. Magashule any questions. And before you know it, she excused you and Mr. Mutupi from the meeting. When how did you feel when the PP started doing most of the talking, yet you were under the impression that this was meant to be an investigative meeting where you would take the lead in terms of asking Mr. Magashule questions?
When it started, I just thought maybe we should allow the PP to go on and ask questions, and maybe after that we would be given an opportunity to ask our questions. But the meeting was suddenly ended after maybe 30 minutes without being given an opportunity. So with regard to my feeling, I felt that I did not achieve the objective of the meeting, or of the objective of calling Mr. Magashule to the office.
Did you get the feeling that the PP was trying to shield or protect Mr. Magashule from answering the questions that you had prepared in advance?
Not really, but I wouldn't express opinion or having feelings like she's trying to shield him. But I just find it very strange that the meeting was then adjourned and then there was this personal meeting to happen between the two.
Thank you.
Thank you. Before I recognize Honorable Heron, I see your hand, Advocate Mpofu.
No, Chair, it's fine. I think it's late at night now. It's all right. Thanks.
Thank you, Honorable Heron.
Thank you, Chairperson, and thank you, Advocate Redani. Advocate, I'm trying to understand the part of your evidence in the affidavit and the oral evidence you gave regarding your departure from the Office of the Public Protector. You make reference to an unpleasant working environment and that you had a perception that you were being targeted. And you say that you thought that you may have been targeted because you were involved in the PSA. I mean, what are you trying to share with the committee with these paragraphs 11 to 18 or 19, 20 about being a target, your perception about some people leaving the office, but you didn't ask for reasons and no one gave you reasons why they left the office? What is the purpose of this evidence?
For me, I wanted, the purpose of this evidence was clearly to demonstrate that even though I left out of my own will from the Office of the Public Protector, but the environment was not conducive. And what actually I could see, what actually was happening to some of the union leaders, I could see that it was inevitable that it's not going to happen to me. Hence, I've made that reference, and I made it clear that I've never had anything personal with the PPO. But what I was hearing, it's a corridor talks. It's corridor talks from people who will come and inform us what is happening.
But I mean,
so the main.
Carry on. Sorry.
Yeah, you can go on and.
No, I was going to say the advocate Nkobani is facing a charge of intimidating, victimizing, or harassing staff. So are you saying that you were intimidated, victimized, or harassed?
From what I heard from the corridors, like I said earlier, I had a perception that I was also part of the people who are not wanted in the organization, because I was vocal as well as Advocate Matlawe. I will raise issues when it's the relevant time for me to raise issues. If there are things that I don't agree with, and I will then raise them.
But were you intimidated, victimized, or harassed?
No, I wouldn't say I was intimidated, but I could see that where the direction was, where the wind was blowing, the direction in which the wind was blowing was going.
Then Advocate Radani, I mean, I don't see how that relates or correlates with some of the rest of your evidence. I mean, in paragraph 19, you say that you had professional disagreements with the public protector. In paragraph 67, you indicate that while you were drafting this late night draft of the Freda report, you expressed your disagreements. And then in paragraph 73, you refer to being instructed to then investigate the second Freda dairy report, Freda report, and you were invited to attend, or you led the meeting with the former Premier of the Free State. So if you were a target and you felt like you were a target, why would Advocate Nkobani keep you involved despite your personal differences or professional differences, you're disagreeing? Why would you stay involved almost till the day you resigned?
Certain things were allocated to us based on whatever the skill that management thinks that you possess. And when I say professional disagreement, I was referring to a situation where, in terms of investigation, I would hold a different view, and the public protector may hold a different view, and then her view will be the one that goes on. Or sometimes I object to certain things that I don't believe in when it comes to issues relating to the workplace. So I don't know why I would say certain investigations were given to me. I made reference to the SAA investigation that I was doing, and also this one of Fred. I wouldn't say it has what happened earlier on in 2017 and 2018. It's not what was actually happening around September, November 2018. The situation was worse from what it was before, a year before. Hence, I'm saying, so it is not necessarily correct that the environment was conducive, was not conducive when these files were allocated to me. So I believe
the files, Alex. Sorry, Mr. Randani. I'm not going to get a lot of time, so I want to cut you short if I can. You were allocated work. You continue to work with the public protector, even though you regarded yourself as a target.
Yes, I continued to work with her because I was performing my responsibility.
Okay. I want to move on, Advocate. We've had a lot of investigators give evidence about the process of investigation. And I wonder if you can just briefly tell us how you regard the process of investigation arriving at identifying implicated persons.
The process, can you just come again?
I want to understand how, if you can tell us how you, as an investigator, would identify implicated persons.
Implicated persons will be identified based on the investigation. Initially, it might not even lead you to those who are implicated, but as you go on, when you investigate, when you gather information, you interview witnesses, you will get witnesses who will tell you that who will point you to certain individual, and you get some independent evidence that point you or implicate certain individuals.
So it's based on the evidence that you...
Based on the evidence that you have obtained during the investigation. It will tell you, it will show you or point you to an implicated individual.
And when you got involved in the Freda investigation in late 2017, was that after the file had been transferred from the Free State office to the Public Protector's head office?
Yes, it was with the Public Protector head office. I think it was under PII investigations.
And when you received the file, I think you gave evidence that you read all the reports that were all the content of the file.
Yes, I went through the contents of the file from the investigations, all the versions of reports up until to the latest version that was presented to me.
And according to Mr. Samuel, who was, I think, at the time, the head of the Free State office, is that correct?
Yes.
There were several versions of this report. There was a November 2014 version. There was a 2016 version. There was a March 2017 version, an April 2017 version, a July 2017 version, a September 2017 version, and then, of course, the November 2017 version when you received the memo or the email from Mr. Ndor. So you went through all of those reports.
Yes, I've went through those reports, but normally what I will take into mind was the latest version, because the latest version will continue the comments from other people. If the reporters went to the think tank, it will also include those comments.
So, what was the evidence that that led to the Premier and the MEC being identified as implicated parties, the politicians that were being ignored or not ignored? What was the evidence that implicated them?
The evidence came in from the fact that when this project came into light, it was the first person who spoke about it in public was the Premier himself in his State of the Province address. And then in the budget vote, the former MEC then also talked about it. And when we scrutinized the documents submitted to us, when we looked at the benchmarking of the project when it started, the relevant person who approved the delegate, the number of the delegates who went to India to benchmark with Brasa, with Paras. The Paras is an Indian dairy company. When those people went to India, the person who approved was Mr. Mahashul. And then the fact that there was later the Accountant General report, which simply requested the Premier and the MEC to take appropriate remedial action against those who were implicated.
So,
should be a last.
yes, Advocate Radani, why didn't Advocate Saliers implicate the MEC and the Premier in her drafts of the report? Because the evidence from Mr. Samuel was that the first drafts of the report did not include identifying politicians, and it was Advocate Madonsela who repeatedly instructed Mr. Samuel to redo the investigations or the reports to include the politicians. But Advocate Saliers' drafts of the report did not have that in it. So why, if Advocate Saliers was following this process of investigation, did she not make findings or in the provisional report against politicians?
Maybe she didn't deem it necessary to make a direct finding against them, considering the fact that despite them being political office bearers, they were not actually involved in the implementation of the project. Hence, a lot of evidence shows the evidence showed a number of wrongdoing on the director, on the head of department, who was the accounting officer.
Can I just follow up? So, Mr. Advocate Randani, I mean, basically, if I understand your answer correctly, maybe the evidence wasn't there when Advocate Saliers drafted her report.
Yes, that's possible. Maybe the evidence was not there, or she ignored it, or maybe she failed to raise the issues that needed to be investigated at the first after looking at the original complaint.
Thank you.
Thank you. Honorable Dlagode. Honorable Dlagode. Okay, we'll skip. Honorable Ngozi.
Sorry, Chair. Honorable Dlagode has indicated that she is attending another meeting, so it might be that reason.
Okay. Honorable Ngozi.
Thank you, Chairperson. And thanks to the legal teams. Good evening, Advocate.
Good evening, sir.
Okay. My first question really relates to the atmosphere in the office, which you have already described. Were you comfortable that the CEO, Mr. Vusi Mahlangu, who did not have top secret clearance, was involved in operations?
Firstly, I was not comfortable, but as the CEO, when it comes to administration, it was part of administration was part of his work. So, for his involvement in the investigation, I was not comfortable with it because. Firstly, one of the things that we as the union questioned when Mr. Mahlangu arrived at the office was that he was facing a dark cloud from his previous employer. I think it was Department of Agriculture and Rural Development.
Okay, thank you, sir. You can respond to this, but did you regard him as, in quote unquote, an enforcer of the PP?
There were some strange things that the CEO was doing, especially when it comes. I will talk to this incident that involved the Advocate Matlawe. I felt that that incident was not necessary because Advocate Matlawe was already on his way out. I think he had less than 10 days to be in the office. I found his behavior very strange, that he will then target people. So obviously he had somewhere where he was driving those powers from to act in the manner in which he acted.
You testified that the PP changed the Friede report or some of the Friede reports. Do you think she had a legal or constitutional basis to effect those changes?
Some of them, those changes that were effected, especially something that has to justify why we could not investigate, hence we have the evidence. I really find it, I don't think there was a constitutional basis for that or a legal basis for her to effect those changes.
Do you think that she exercised the responsibility with due care and diligence required of a PP?
I would say, I wouldn't say she was, she exercised with due care or with due diligence, because whatever we have tried to convince her otherwise earlier on in the earlier meeting, and I had conveyed my message to say that this is not going to sit well with the legal experts and analysts, those who analyze tomorrow. And she seems not to be to take much care of my advice or my warning.
You indicated earlier that you had a very professional relationship with her.
Yes, was it purely professional?
Yeah, did she reciprocate? Did she, in other words, also display a professional relationship to you? Or do you have a view that,
in as far as I know, when it comes to me, she has never shouted at me. She has always been professional. So I don't know if she has ever shouted anyone else, but I have heard her saying people should be charged where I didn't think that those particular people need to be charged.
With regard to the Gupta leaks, do you think that she had any basis for either ignoring or instructing some to ignore these leaks?
No, there was no basis to ignore the Gupta leaks because some of the emails dealt with this project specifically. So I would say there's no basis for that to ignore the Gupta leaks email.
The reasons provided for not doing further investigations on the Friede project was that there were no sufficient funds to either continue the other legs of the investigations. Is this your view, that there was no funds?
I don't share the view that there was no funds. I think a thorough investigation was done by the Free State Office. And
okay, sorry.
No, you can go on and ask your last question.
My last question, sir, is you left the PP voluntarily, but in your evidence, but in your evidence, you indicate that the environment was not conducive for professional conduct. Do you have a feeling that you left before you were pushed?
Yes, I have that feeling because a lot of colleagues that were disciplined after my departure. So I think maybe if I had stayed, that day would have maybe arrived.
Thank you very much and good evening. Thank you, Chair.
Thank you, Honorable Ngosi. And I recognize Honorable Skosana.
Thank you very much, Honorable Chair, and good evening to everyone in the meeting. Bora Ndani, Ndimatekwana.
Ndimatekwana Udi, what's concerned?
Advocate, according to your affidavit, you started working at PPSA in 2008, but you were only transferred to the private office in 2017. That was after the arrival of Advocate Mkhwebane. Is that correct?
Yes, that's correct.
Now, the question is, why were you transferred to the private office and by who?
Initially, I was given a letter by the CEO, but I think the transfer should have influenced by the acting chief of staff at that particular time, and then my executive manager, who Mr. Mutsidzi, I think they discussed, and then that's when I was transferred, and maybe with the PP's blessing, because I think I got a formal letter.
Okay. So why would the PP agree to your transfer to her private office while you were her target?
Remember, the perception or the feeling that thought was the target, it was long after that has happened. At first, when the people, at first, maybe the PP did not have any issue about, they did not have issues, or there was no such perceptions that I was a target before. This thing only came in after 2018. And that was after the Friday report was issued. So that perception only came in after, in 2018 later. So,
okay.
So I wanted to say, basically, at the time when I was transferred to private office, that perception, I didn't have that perception.
So the issue of you being the target, it was influenced by the Friday Dairy report. It was not influenced by the fact that you were, according to your affidavit, by the fact that you were close to the previous PP. I think that's what you said in one of the paragraphs, that people who were close to Advocate Madonsela were targeted.
Yes, people who worked closely with Advocate Madonsela were targeted. I don't recall. There was that perception that everything that has to do with Advocate Madonsela should be done with and then dusted. So it might, it's something that I considered that it might have influenced, it might have led to the environment not being conducive to me in 2018.
But you only noticed that after after we have dealt with the issue of the Friday Dairy report.
Yes, after the dairy report, because we discussed it after. I went to discuss with my colleagues what transpired in that day with me when I was sitting with the PP. So maybe I don't know whether that word reached her or any other thing, but there was that perception after that.
Okay. So in paragraph 18, you say, in your view, you were targeted by the PP because you were part of the leadership of the union. So the question is, did you, as a union rep, in any way, undermine the authority of the PP at any time?
No, we have never undermined the authority of the public protector. something that we would have done if we have disagreement with the public protector, we will just straight go to her or voice our concerns through relevant structures. Like, for example, we had the bargaining forum wherein we raise issues that we did not agree with management.
Okay. My next question, in paragraph 19, you say you gave the PP independent and sound advices, which were not always aligned with her wishes and objectives. What do you mean by her wishes and objectives?
Like, for example, when I was working, what I mean is, if you give an opinion, or if you express your opinion on certain things, and you could see that this person doesn't want this opinion, then you can conclude that that is not aligned to her wishes or objectives.
All right. My last question. When the PP dictated to you what changes she wanted in the report, was this based on the evidence that was collected, or what?
We had a report which was based on the
referring this to the Friede Dairy
report, yes.
Report.
Initially, the report that went. Can I answer, Ms. Honorable Speaker?
Yes.
Okay.
Yes,
initially, the report that we presented to the PP was backed up by evidence. The changes that she made might have been backed up by evidence, or some of them might not have been backed up by evidence. So I really wouldn't say whatever that she did was not backed up by evidence, and I can point to specific. But the main issue that came out of is the issue relating to financial constraints faced by the office at that particular time. That was not backed up by evidence, or to include it in the report, because I will not know how was the financial position of the organization, because I was not the CEO or the CFO or the CEO who are privy to such information.
I didn't get the last part. Are you done? Okay, Kichimani.
Yes, I'm done, Chair.
Thank you. Honorable Mautu.
Thank you very much, Chair, and good evening to yourself, the colleagues, and Advocate Randani, and the PP's legal team. Advocate Randani, would you say that you would never go back to the office of the PP while the PP is advocating Quran?
Yeah, that depends, but I don't see myself going back to that office while she's still the PP.
Can you, under oath, tell this committee that you've never reapplied for any position in the office of the PP during the term of Advocate Mkhwebane?
I have applied at some point, but I regret that decision of me applying for those posts. I think that was in 2020 during the COVID.
Okay, I'll move on that one. Now, point 16 of your affidavit, and I'm going to read it. You are saying that those of us who had been investigators in the private office, including Advocate Matlawe, Mr. Pukana, Mr. Stole, Ms. Sefago, and your good self, were moved out and placed in the Provincial Investigations Branch under Mr. Reginald Ndu. We were simply informed that you were being moved by the CEO. I was not provided with reasons for the move. At the time, I did not ask for reasons. Now, why do you deem it fit to name the employees who were moved out and placed in the provincial branch under Mr. Ndo? How does that assist this committee?
When I wanted to, my intention when I come up with that evidence was to simply indicate that we did not stay that much, that we didn't stay for a long time under the PP's office, because initially there was no staff, no investigative staff that was supposed to report to the PP. So we were then, all of us, we moved to provincial.
So you are speaking on their behalf here. You keep on saying we, even now.
No, I'm talking about the staff members that I was reporting with under the senior manager executive support. We were all transferred to PII. If it was me alone, I was going to use the word I.
Okay, let's move. Is it possible that all the allegations against the PP by the disgruntled employees, some of which you've mentioned above, could just be products of their own imagination?
There's a lot of things that happened in that office, which a lot of people, even though some of them don't want to talk, don't agree with. So I don't regard these allegations as just baseless, although some of them might have been influenced by the fact that they are bitter. But I don't regard the allegations as just ordinary allegations. These are serious allegations because there's a lot of guys who lost their employment in the office.
Are you bitter yourself?
No, I'm not bitter.
Okay. So you just mentioned that some of the issues are very serious. Do you believe that if a woman reports sexual harassment immediately, it means she is driven by vengeance?
It depends on the circumstances, ma'am. If I'm dating a woman today and we exchange whatever that we're exchanging, and later on when we are no longer together, that woman reports sexual harassment, that's something else.
You're speaking here, it's Women's Month, and I don't seem to appreciate the sensitivity around sexual harassment and general GBV against women.
I appreciate general gender-based violence against women. I respect women, especially when it comes to the issue relating to sexual harassment. But my answer to you was specifically saying, it depends on what context that sexual harassment is raised. If sexual harassment is raised by somebody who was in a relationship with that particular person, then it's something else. And that sexual harassment is deemed to have occurred at that time when those people were in speaking terms. It's something else.
I'll move on that one, although I'm not quite happy with your response. Now, Advocate, after your performance here today of telling us about perception this, perception that, do you really think that this committee can take into account anything that you've said today? Or can we rely on your evidence that is premised on perceptions?
I don't know. That's what I'm saying. It depends on your view, ma'am. If you are sitting and listening to a particular witness and you decide as a person who need to take a decision about that particular witness, and you say, I don't know, and want to disregard that evidence, maybe you have got reasons enough to do so. But I don't think my time was a waste of time to appear before this committee, because whatever that I related about the meeting, those things happened.
And the perception?
No, I'm not talking about perception. The report was changed. It's there's no doubt about that. So if you think that I was, when I refer to perception and other things, I was wasting my own time, then that's what you need to, what you want to believe me.
So according to 0.6 or in line with 0.6.3.1.2 and 6.3.1.3, do you agree that the PP didn't conduct a comprehensive investigation in order to determine the fair market value of the goods and services, and she was not provided with all the invoices and proof of payments?
On 6.1.
6.3.1.2.
6.3.1.2.
And 0.3.
No, the 6.3 moves straight to 6.4.
Of the
Or
report.
are you referring to the of the report? Okay. The PP was able to source somebody who could inform she was able, because she was able to source services of someone who can determine whether the prices of goods and services were inflated. But she chose not.
That's the question. Do you agree that she didn't conduct a comprehensive investigation?
Okay, can you ask the question again? She did not, because the people who went over to do that exercise were the Free State Office during the course of the investigation.
Sorry, come again. I lost you a bit.
I'm saying that the public protector was in a position to conduct such a comparison of what was the fair market value of each and everything, but she chose not to. However, there was an exercise that was done by the investigators from the Free State when they were initially investigating this, which that exercise the PP disregarded. And as to the invoices, I have no comment whether she could not do that in terms of, because she had no invoices. I don't think the invoices were necessary, but I think she should have taken into account the evidence of and then the analysis done by the investigators when they arrived to a point that there was the prices were inflated.
Is it correct that in labor law, the workplace continuous non-performance may result in misconduct charges? When you continuously perform poorly?
When you perform poorly, and after certain measures have been taken to address your peer performance, then it can lead to misconduct.
You know, Advocate Randan, I don't understand you. Why you grown-up black men like yourself, Mr. Kekana, Mr. Samuel, prepared to risk your career just to drive the agenda of the DA and the ANC? Like, it beats me.
I'm not a politician, ma'am. I've never drived any political agenda. I don't have any membership with anyone. I'm just a lawyer. So I'm not risking I'm not saving the interest of anybody. What I'm here for is to give evidence, read the report, and also what happened when I was the public protector. And I have no intention to cost the public protector her job. I'm just assisting the committee to arrive to the truth.
And in your view, what is the truth?
The truth is what actually transpired in 2018 and in the years that I was in the OPP when the PP arrived.
So is it only the bad side that happened? Nothing good happened during that time?
There's something good. I was telling Advocate Mpofu SC earlier on that legal services should also be given reports to comment on. For me, it's a positive, because I said to Advocate Mpofu that it was beneficial. I can mention a lot of things that she has done, which I agree with.
Including the fact that she's the first PP.
That will be a last point.
Okay. Also to include the fact that she's the first and the only PP to have had clean audits 2 consecutive years.
Yes, I have heard about the clean audit, but primarily I wouldn't give her a credit. Clean audits has to do something with people who work in finance and the accounting authority or office of the organization. Although she might have contributed immensely towards that achievement.
So according to you, it doesn't matter. I mean, in the current situation where we have municipalities not having clean audits, it's okay. You can just blame the finance people and not the accounting officer.
It's not okay. You need to blame those people who are directly linked towards the achievement of the clean audit. For example, you are making an example of a municipality. Will you blame a councillor if there is no clean audit in the municipality, or you will look into the accounting officer who is the municipal manager?
Well, I'm not here to answer questions, but I will look at the accounting officer the same way the PP is the accounting officer of the office of the PP.
The PP is not the accounting. The PP is not the accounting officer of the office of the PP. She is the executive authority. The accounting officer is the chief administrative officer, which is practically referred as the CEO, but in the act is the chief administration officer.
And they report to the PP?
They report to the PP.
So it remains the PP's office?
The PP is the overall executive authority of the office.
So these clean reports where she must get credit for them because no one has ever done them.
Your extended time has lapsed. Honorable Ompile Mautwe.
Oh, Chair, can you just answer this last one that I've just posed? Is there
I know he will answer. I will allow him to answer. Thank you, Honorable Mautwe. Go ahead, Advocate Raidani.
The clean reports, I'm saying specifically, I wouldn't give credits directly to the public protector for the clean reports. The clean reports has something to do with the accounting officer of the organization. But I do not want to detach her from that achievement because it happened under her tenure.
Okay. Thank you, Honorable Mautwe. Thank you, Mr. Raidani. I now recognize Honorable Maneli.
Thank you, Chairperson. And greetings to Advocate Raidani. Can you hear me, Advocate Raidani?
Good evening, sir.
Thank you. Chair, I just want to check a few questions that may have been asked and then get to the point I want to ask. With regard to paragraph 50, I just want to ascertain because this is a direct meeting with the PP and one of the witnesses that would have come before the committee. Can you recall what were these specific instructions you needed to carry out in order to meet the standards of the PP for an approval of a report? And maybe more specifically as to whether amongst those there would have been adverse findings on politicians that you needed to remove, as well as the inflated costs that would have been picked up by the investigation. Thank you. Chair, through you.
Okay, do you want me to point at specific things? One of the things that she instructed us to remove, I think I've gone through that in the morning before lunch. If you go to if you go to the report that was submitted just after to the draft, you could see clearly that some of the findings have been altered in order to reflect what the PP wanted. Like for example, in page 3047 in the report, in the earlier report, the report says that the earlier report had a finding that the procurement prescript were not followed in respect of the Estina agreement, and that constituted maladministration. But in the later report, which was changed, it just only noted that there was non-compliance with normal procurement process, but did not categorize that as maladministration. And then another example would be a reference to section 217 of the Constitution, which rendered the conclusion of the agreement improper. That is in 3047, the PP made reference to the Constitution, but she did not conclude that there was an improper conduct. So those are the things which are which can be visible from the reports, as you can as the advocate Power was making comparison earlier. So what has actually been changed by the PP in that this initially it was one of our instructions that we go on and put the issue relating to financial constraints and all these other changes that came into on the 8th of February.
Thanks, Chair. The reason I'm putting these three, I'm very specific on them. Because as I said, there's also other witnesses who would have come. So I want to establish the meeting itself, because this is not hearsay, you are meeting the PP directly. So this is important to get an answer in that regard. Whether amongst those instructions, maybe leave the others that I would still want to come to. Whether the politicians, there were adverse findings that you needed to remove as a result of this meeting where the PP is directly there. Secondly, whether it also talks to the inflated prices that were discovered by the investigation. So I'm making those, Chair, as specific over and above other instructions that may be referred to, whether it is in that meeting that would have come out. Thank you, Chair.
Yes, it is in that meeting where some of these instructions did come out. The issues relating to the inflated prices did came in, and then the fact, the comments that maybe there was no thorough investigation on it, then that was the instruction that were given in that meeting, earlier meeting with the PP, to go and change the report to reflect what the PP would consider acceptable for her to append her signature.
No, thank you, Advocate. If I may just go quickly again, Chair, I'll just make reference to the paragraphs that my question is linked to. Paragraph 54, I'm taking that up until 70. So I'm just making that reference so that the question is understood comprehensively.
Yes.
Because I'm trying to check the relevance of bringing this point for the attention of the committee. That the concerns that you are raising, bringing before this committee on the material matters that have been removed from the report. Is it about a reflection on the Office of the Public Protector under the leadership of the PP that is seen to be incompetent given its functions? Or is it about demonstrating that information used was misleading or dishonest? Or is it about being worried about an impression that the Office of the Public Protector under the leadership of the PP has failed to hold officials and politicians accountable in the eyes of the public? Or is it all of the above? Thank you, Chair.
what we're trying to show here, what this paragraph 54 and going on is trying to show here, it's simply that something rather than evidence influence the changing of the earlier version of the report to the changing of remedial action on the earlier version of the report to what the final report has reflected, which is to absolve certain people of wrongdoing. Hence, those people have been in the earlier version of the report been pointed to be being found to have not followed proper procedures and also committing maladministration as it appears in the earlier version of the report rather than in the latest, in the signed version of the report.
Thanks, Chair. If I may just make a follow-up on that point. I think my question really talks to what we are dealing with as the committee. So if you think it's none of the above, you are also able to say so. Because you've brought all these points, and that's why I had that A, B, C, and C. And I think in the response you are giving, I'm trying to make sense of whether you are getting to that point or not. Are you trying to bring to the attention of the committee that having raised those points, it's a concern about the way the Public Protector's Office is looked at under the leadership of the PP as incompetent, or you are also saying that probably the information put out also reflects dishonesty or it's misleading in the way that information is put up, or you are also concerned that the PP's office will also be seen in the eyes of the public because it's a public protector office that I talk about, in the eyes of the public, that it's seen as not being able to hold officials and politicians accountable with all these material matters that have been removed in the actual report. That was the question, Chair. But of course, if there's none of the above, you'd indicate so that I move to my last question.
Correctly, you correctly stated it as you're saying that the act of changing the report to absolve to clear certain officials and certain people who initially would have been found, the findings would have been made against them. It's entirely a question of whether the public protectors are not taking action against certain people, even though there's enough evidence available to do so. So that's what the public is looking at. The public might else maybe can reach a conclusion just based on what you said in this report.
Just pause, Advocate Raidani. Advocate Mpofu.
Chairperson, through you, can you ask this witness to stop reading whatever he's reading? Or he must tell us what he's reading from, whether people are feeding him with information or he's reading from a document.
Thank you, Advocate Mpofu. We'll attend to that. Advocate Raidani. The Jenny.
Okay, I think I have heard what Advocate Mpofu was saying. Advocate Mpofu, I'm not reading. I'm just looking at this the paragraph as the honorable was asking question. Because he referred to paragraphs, I'm just looking at the paragraphs. I'm not reading. The answer is not coming from those documents.
Okay, Chairperson, all right. I don't want to belabor this. We'll demonstrate by playing this video that the man is lying. And he's been reading when there were questions that had nothing to do with any paragraphs. But I'll just leave it at that, Chairperson. We'll play the video at the correct time. Thank you.
Thank you, Advocate Mpofu. Proceed, Advocate Raidani. Proceed, Advocate Ndicheni Raidani.
Okay. Yes, and okay. Before I was paused by by Advocate Mpofu.
Complete what you're saying.
What my answer is simply by just taking into account what has been done in that Friday report, whereby the certain findings were directed into a certain direction. It cast some doubt on the Office of the Public Protector on whether some people whom there is evidence against can be cleared regardless of that.
As I said, it will be my last question.
Yes,
I'm
it will
combining paragraphs 74 and 75 together.
As your last point.
Yes, Chair.
Thank you.
I just want to check because other points I'm covered with this question, but just for purposes of understanding what happened, is it your version that in reality, from a point of an appointment as an investigator, it was about investigating the former premier of Free State, and you did not have an appointment with the SG in that regard from a point of investigation, so that one can also have an understanding that indeed you would not be able to be in one meeting if you don't have an appointment to get in that regard. And will that be the reason why you are bringing the point about the SG in your affidavit as a way of separating relationships that may be there, that yours was on investigation and you would not know the other meeting because you don't relate to it from a point of being investigated. Thank you, Honorable Chair.
Yeah, that's correct, Chairperson, that from the investigation point of view, it was us investigating the former premier of Free State rather than the Secretary General of the ruling party. So what the honorable member has just said now, it's correct. So there is a difference between because the act that wouldn't even allow us to investigate the Secretary General of a party. So the ours was only confined to his tenure as the premier of the Free State province.
Thank you.
Okay, thank you. Honorable Ngola.
Thank you very much, Chair. Advocate Rendani, have you seen or read the remedial actions on the Fred Dairy project report?
Which one? The one?
The final report.
The one that we are talking about today.
Yes.
Yeah, I have seen those remedial action.
Okay, thank you. In your affidavit, paragraph 7.7, you say there, as part of the PPSA investigators, part of what you were obligated to do was to assess whether the remedial actions were appropriate and lawful. Now, having to check the investigation into the project which you were part of and the remedial actions, would you say the remedial actions were appropriate and lawful?
The remedial action mainly should speak with the findings. I think the findings has to do the remedial action was directed to the Premier. Let me just verify if it was indeed directed to the Premier. And just bear with me while I'm checking the report. Okay. Yes, the first person to be referred to be directed the remedial action was the Premier of the province, and he was requested to initiate a disciplinary hearing into the official involved. And I think I alluded to that point earlier when I said that the officials that were involved in the project included also the head of the department. So by looking at the findings, the way in which are written in this final report, the remedial action were correctly directed to the Premier of the province because the findings were made against officials of the department.
Okay, let's take this matter that you were redeployed to a provincial office or somewhere else without having been provided sufficient reasons for that particular action by the institution. As an advocate and as a labor unionist, do you regard that action as a just administrative action and a fair labor practice?
I think fair labor practice will be determined by what is fair at the particular circumstances, and the circumstances at that time. When I was redeployed from the PP's office to PI, hence I never questioned why I didn't have a problem. That maybe I didn't see anything unfair about it. And I accepted the redeployment and went on to work with Mr. Ndo and
Maybe you can switch off your camera so that we can hear you as we move on. Your network is struggling. Can you hear us now? Can you talk?
Yeah, I can hear you, Chairperson.
Okay.
Do I need to answer that question, or you didn't?
We last heard when you said the fair labor practice will be determined by, then you were gone.
Oh, okay. I was saying that what is fair will be determined by the circumstances of each case. And I was saying at that particular time when I was transferred from the private office to the PII, I didn't actually have any objection to my transfer. Hence, I didn't look into the fairness of it and the unfairness part of it. So I really don't say it was unfair. It might have been unfair to someone who wanted to remain in the private office of the PP. But with me, I had no problem.
Okay. Let's go to what you term as the dissolution of the think tank. In your view, what has been the impact of the dissolution or the discontinuation of the think tank into the quality of the reports from the Public Protector South Africa?
The think tank was a crucial committee which was introduced by Advocate Mushwana, and it had to look into the quality of the report. Obviously, after the think tank was dissolved, the standard of reports went down. The quality was not that enough. It was not of that standard when the think tank was still operating.
Okay. You spoke about the Gupta leaks. or else what has been termed as the Gupta leaks. And you spoke as though that there was this instruction that the Gupta leaks must not be used in respect to the investigation and the report of this investigation in question. Do you mind telling the committee where did that instruction come from? And were there any particular reason?
The person who came to tell us about the Gupta leaks.
Sorry, Advocate Randan. Can you hear me?
Yes, I can hear you.
Can I repeat the question for you?
Yes.
Where did the instruction not to use the Gupta leaks come from in your understanding and knowledge? And were there any particular reasons that were given for those leaks not to be used?
The instruction the instruction at the initial meeting when he informed us that the PP wanted to sign the report, we raised the issue of the Gupta leaks, and that's when he told us that the PP doesn't want us to follow that avenue.
Are you done?
Yeah, I think I've answered you. You wanted to know the source.
No, it's fine. Let's agree that there has been a maximum embezzlement of public funds in respect of the dairy farm project.
Yes, that's correct. It's a maximum that the funds were embezzled there.
Okay. Would you therefore agree when someone says, amidst that embezzlement of the funds, the public was not protected by the Office of the Public Protector?
Yes, I can accept that there was that during that process of the embezzlement of the fund, the public protector did not play its role, but it was difficult it was not easy for the Office of the Public Protector to intervene. And at that particular time, ours was only to investigate and report on that conduct as required by the Constitution. So if we have failed into reporting part of it.
Okay. The last issue I would like to raise with you would be the first witness that came to the committee spoke about the entire purpose of establishment of the Office of the Public Protector, which in any case he referred us to two cases, the first certification case and the second certification case. But in both these cases, there is an agreement that the Public Protector's Office is a very important office for the people's democracy. It was given a status of a part of some sort of an ombuds. So when you were approached by the evidence leaders to come and give testimony in this committee, was your agenda against the incumbent public protector? Was the agenda for the benefit of the Office of the Public Protector, whose importance I've just explained? Was the agenda about the people of South Africa whom have suffered out of everything that you have outlined in this committee?
The agenda, it's about the office and the importance in our constitutional democracy, and also about the people of our country who should go to that office and get assistance free of charge. And I wouldn't say that I had any agenda against the incumbent, but the agenda was to help the committee into arriving at the truth based on whatever information that I can share with the committee about my time then at the public protector.
Okay. For your information, that is the only agenda that is bestowed upon this committee. There is no DA agenda that is here. Thank you very much.
Thank you, Honorable Mola, and thank you, Advocate Ndicheni Raidani. Maybe just before we go towards conclusion, maybe 3 quick issues that I just want to test with you. Can you just indicate briefly, if we did not have this inquiry as the National Assembly, were you ever going to raise these issues and report them, the ones that you have placed in your affidavit?
There was no appropriate forum for me to raise them, unless it failed to raise them, because I couldn't raise any complaint, anything that was committed by the public protector when I was within the public protector, because she was there. So basically, to be honest, had this process not been there, I was never going to raise the issues that I have raised today.
So you would recommend to us that there's something about the institution that you need to think about as members of parliament beyond an individual who's a public protector?
That's correct, Chair. There's something that you need to look at as members of parliament about the institution of the public protector.
Okay.
Incumbent.
Thank you. We'll take that as our homework as well. Were you in the employ of the Public Protector South Africa when it emerged that certain records in court were incomplete in terms of 53? Were you in the employ of the Public Protector then?
In relation to which report or matter?
Whether it's CX report, or Fred or whatever report where you do these records were incomplete.
I can't recall the one that the Rule 53 records that I was involved in, because I was even involved in as far as consultation with counsel for this case of Fred. I'm the one who assisted the office there. The head of legal to compile the records and furnish them. So I couldn't recall if such Rule 53 information was insufficient.
Okay. My third area of brief reflection with you, I don't know how you call that in vendor or Shangan, but it's brought into your affidavit. I want to go back to this. You introduced this thing, Anginandaba, as you coined it, as something that the public protector would use. Would this Anginandaba phrase be used in a jovial way or informality amongst colleagues? Or was this in a formal setting?
No, when she actually said Anginandaba, we were just sitting with two of us we were just completing that report. And it was just after I said, this report tomorrow, everyone will be talking about it and the legal process. So that's when the phrase was used. It was never used formally. It is something that she said made informally.
So it would not define her leadership style.
I wouldn't say it was if it was in a recorded meeting and a formal meeting, but this was not a meeting. It was just we were just working on a report.
So Advocate Ndicheni, so if this would have come into your affidavit, were you bringing a gossip to us?
No, I was not bringing gossip. My main point was to say that I have expressed my reservations about the report before it was actually published. And indeed, the report was criticized the following day, left, right, and center.
Okay. I will pause there. As I go to the evidence leaders, Advocate Mpofu, you were trying to disrupt me. What did you want to raise?
It's okay.
No, Chair, I'm saying I apologize. I was just trying to bring my hand to your attention because it's been up since you started. No, Chair, I was not trying to disrupt you. I'm just saying that I'm objecting to your last question. You are again misrepresenting what the witness said. He never said, like you say, that this used to happen and it used, as you say. He says at paragraph 67 that there was a specific instance where he was talking about commentators, the noisemakers out there. He was worried that they would say this or that in a particular setting. And then she says it was in response to my concern that the PP said, Anginandaba, in relation to that, not what you are saying or that it used to be said and was it said in this. That was never said. It's just misrepresenting the evidence. Thank you.
He has already answered my question. Thank you very much, Advocate Mpofu. I now recognize the evidence leaders in terms of 616 and 617. If there's any issue you want to raise.
There are no issues of clarification.
Thank you. Advocate Ndicheni Raidani, you can switch on your video again. We have now reached the end of our session with you. Do you have anything to say to the committee?
No, I actually don't have anything. I think I have. It has been quite a long day for me. So,
would you prefer more questions, or should we stop it here?
No, I think we should stop it here.
Okay. Thank you very much, Advocate Ndicheni Raidani. Thank you for making your time and coming and make your contributions through virtual. We appreciate. Hopefully your contributions are going to assist us in our work. You are now excused. Before we close, honorable members, just to make a couple of announcements. The time now is 8 o'clock. We will pause. Tomorrow, we are asking the legal services, the evidence leaders, as well as the legal team of the public protector to give us an indicative program of the remaining witnesses. For that, tomorrow we'll not have a session. We'll allow for the time for that to be done. This committee work, the ordinary committee meeting will take place on Tuesday, where we receive that program as a committee, and we'll resume with our next witnesses from Wednesday next week. So you would have, there is no rest, because both the teams and ourselves, the other work that we're going to do. So I thought I must make those announcements first about, that's why I would have stretched this up until late today so that we're able to conclude with this witness. Because the important thing is that by next week, we must have a picture of our roadmap. Having done 9 witnesses by today, what's left, where are we going? We certainly on Tuesday will be discussing that in our ordinary committee meeting and resume the inquiry and the hearings as from Wednesday next week. Thank you very much. I want to adjourn the meeting. I'm not recognizing any hands, but Honorable Lothrit.
Thank you, Chair. Just for clarity and planning purposes, will the Tuesday meeting be virtual or hybrid?
I actually wanted it to be physically here, but I'm overruled. So it's a rare moment that it will be virtual for Tuesday. So thank you very much. But before we leave, before we adjourn, it's a pity because he was going to enjoy this tomorrow, that we'll acknowledge Honorable Tola Ngola. He has a birthday tomorrow. So maybe that's the reason we're not meeting. Thank you very much. The meeting is adjourned. Thank you.
Recording stopped.